Look Stewart.
I go to
Stimulation Club.
Woo! That's my boy. Give me a kiss. Mwah!
The Early Stimulation Program is an early intervention program assisting all children who are developmentally delayed to reach their highest potential. And so we have children being referred to us from various agencies and institutions. What we do at the Early Stimulation Program is an assessment to see where the child is at developmentally, and then we take it from there. After the assessment, a program is tailored to suit the need of the child, the developmental need of the child.
We have a very set of special needs children. We have cerebral palsy, we have physically challenged, which means they are wheelchair bound or they use walkers, which is the head is bigger than normal. We have microcephalus, which is the opposite, which is a smaller head. We have mentally challenged as well. We have Down syndrome. Parents, that's a major thing, major challenge. Parents who won't help the children. You can see the potential in a child when they come here, and you know that this child can move on to other things. But when you give the child things to do at home, the parents, it comes back the same way that you send it home.
The Early Stimulation Program operates a community-based rehabilitation program as well as the Child Development Center. The Child Development Officer, which is the link between the home and the center, takes a tailored program for that child into the home. What the Child Development Officer does, she breaks down the tasks, the activities for this child development, and model the activities for the parent or the caregiver to carry out the activities throughout the week.
You have some children with disabilities, they're at home. They can't go to school, they can't go anywhere, they're just at home. And the home-based program actually gives these children a chance in life. You know, it helps them because we have officers that goes to the homes, we work with the children, we play with the children. I mean, it even helps the parents.
My child is 5-year-old and she has the Down syndrome. But since I care her here, I see so much improvement in her. You come like she naturally attack now, and she couldn't attack. Your advice is there.
My grandson is 5 years old, right? He's been on the program for over 4 years now. And he do a lot for him, because he couldn't talk none at all. And now he's saying mommy and daddy. Wherever anyone trouble me, can say who trouble him.
Honestly, at first, I didn't want to because probably I didn't come to realize that my child really needed to be here. But now, I don't see a better place.
There is much more that needs to be done for children with special needs in terms of the various system approach, how we work with them, how we see them, because I think this is a community that should be given priority. We should see them as priority number one, because these are also Jamaica's children. We, have to understand that these are children first. Regardless of the disabilities, they are children first.
I think people don't realize that they're just as normal as everybody else. And people need to know that parents never go and ask for a child to be disabled or whatever. But with my child, she's my world. And I would like Jamaica to see every disabled child or person as somebody normal, as somebody that does have a disability and nothing else.
I remember about perhaps 10-15 years ago, Jamal Brown, who had a severe cerebral palsy, was referred to the institution, and the parents, they didn't know what to do. They were really distraught having their first child and with a disability, and we encouraged them, we counted with them, and we worked with this child. And the child did, I must tell you, fantastic. He got his GSAT for Calabar. And because Calabar was not accessible at the time, he ended up at Mona High. Afterwards, he did so well that he received 9 CXT with about 6 distinction. This is a child with special needs now, a child with a disability. And he went on to the University of the West Indies, where he graduated with first-class honors. And you know, this makes us very excited to know that our children, regardless of their disability, they just need the right opportunity. And you know, we encourage other parents to really see your child's abilities, not so much focus on the disability, what the child can't do, but to see the child's abilities, because every child can, given the right opportunity, our children can do valiantly with special needs.
Employers, tired of waiting in long lines at the tax office? Wait no further. Government is making it easier for you to pay taxes. As of January 1, 2015, file your employer's annual returns online. No lines, no hassle. Tax Administration Jamaica TAJ will be implementing the mandatory electronic filing of all employers' annual returns. So get with the program and save time and energy. For more information, call 1-888-TAX-HELP. That's 1-888-829-4357 or visit jamaicatax.gov.jm.
There's a long-distance relay that's still on. Many have taken it this far, each leg as important as the next, each challenge faced with determination. Now it's your turn to take the baton. People living with HIV and AIDS and those who are vulnerable need your commitment. It stands in the way of a better quality of life for all of us and our self-respect as a region. It stands in the way of victory in the fight to stop the spread of HIV. Reject stigma and discrimination. Get us to zero.
Hi, this is Tanya Stevens, and I have a message today for our young people. I want to invite you to look at your life from a long-term perspective. I know that the gang thing look glamorous right now, it might be popular, but you don't see no retired gangster, do you? None in a nursing home, none with pension plan. And I think you want a family, you're stuck, but get them the legal way so you can enjoy them without having to look over your shoulder. And remember, a gang is a dead end.
A message from the Ministry of National Security.
The Jamaican economy is primarily service-driven, with approximately 80% of GDP coming from the service sectors. Its primary export industries are mining, agriculture, and tourism, reflecting a heavy dependency on natural resources. A green economy forms part of the Vision 2030 plan of making Jamaica the place of choice to live, work, raise families, and do business. The Green Economy Scoping Study for Jamaica notes that critical to this is diversifying trade and investment and building resilience to shocks from the international economy.
At the level of the economic, we pointed out some things that were being done, perhaps the most obvious one being the broadening of international trade relations and the attempt to reduce the dependence on imports, and with regard to environmental shocks, of course, we brought in the issue of disaster preparedness and climate change policy.
Greening the economy entails shifting the focus towards sustainable economic practices through the use of natural resources and enhancing productivity through a highly trained workforce and thriving micro, small, and medium-sized enterprises. Effectively doing this means mapping the country's approach to the greening process through a scoping study. But why a scoping study? The scoping study, which forms part of a larger regional study, was commissioned to provide useful information to key stakeholders in order to improve the formation of practical and policy initiatives to advance an inclusive green economy in Jamaica. The study was a collaboration between UWI Consulting Company on behalf of the Government of Jamaica and the United Nations Environment Programme with financial support from the European Union. The Green Economy Scoping Study for Jamaica points to 5 sectors as its focal point, namely agriculture, construction, energy, tourism, and water.
Now, this study came up with several recommendations, and they span across different sectors. They include promoting inclusive growth, diversifying energy, water management, provide financial incentives for greening, and public-private partnership arrangements. Now, from my study of the literature, a lot of countries that have a 2030 vision have similar recommendations, so no doubt these are definitely plausible, and we look forward to Jamaica including these.
Let's take a look at agriculture. The study found that the successful greening of Jamaica's agriculture sector will depend largely on how well the country can capitalize on new emerging production opportunities and markets for green goods and services. There have also been programs geared towards resuscitating and improving production in certain key sectors in the industry, such as ginger, Irish potato, onions, banana, coffee, cocoa, and turmeric. The study recommends the following strategies for moving the sector forward: support for sustainable land management, enacting land reform, creating improved water management systems, providing incentives for investments in green technologies, diversifying energy sources, conducting research into climate-resilient varieties of plants and animals, providing green agriculture extension services, and creating a policy framework for greening agriculture. The study determined that the greening of the construction industry is a multifaceted process that cuts across many sectors of the Jamaican economy. The industry is increasingly affected by the effects of climate change.
In design, there are many things we can look at. From how we situate buildings, passive cooling, so we use less energy. We have a lot of buildings that are badly designed. Even in clearing a site, you need to be careful. Are there trees on the site that would be useful for shade later? Are there parts of the building that you're taking away or removing that could be used in the foundation? There were all these things that they mandated us to look at, and I thought this is really something that everybody should do. And it's not hard, it didn't cost me anything, it just required me to put a little effort and thought. And I really think there is much more of that we could do.
Additionally, the scoping study identified a number of strategies for the construction industry. These include enacting the National Building Act and enforcing the new Building Code of Jamaica, adopting codes and standards that mandate green construction practices, developing a local green building rating system, reviewing and revising the existing development orders and other planning guidelines to reflect sustainable planning principles, providing financial incentives for the use of green building solutions, while expanding training programs in sustainability-related fields to ensure a sufficient supply of adequately trained workers. Jamaica's green economy must also be looked at in the context of its energy mix. Ideally, the country would need to trade in its dependency on imported oils for renewables like wind and hydro energy.
Energy, if it's too expensive, if it's not readily available, if it's not accessible, is going to be a brake on any economic growth of any color, whether it be green, blue, brown, black, or whatever. So you've got to have good energy projects.
Jamaica has already made shrinking the cost of energy a priority, with policies geared towards reducing its carbon footprint. Notably, the study points to several strategies in reaching our energy goals. These are maintaining the exemption of duties and taxes on energy efficiency and renewable energy equipment, increasing the price offered for power to the national grid under net billing, providing financial facilities for renewable energy and efficiency enhancement projects, discouraging the importation of inefficient motor vehicles while encouraging energy-reducing transportation measures, implementing the Energy Efficiency Building Code, and promoting the conservation of energy and water. It is estimated that approximately 75% of the water produced is used for agricultural purposes, 17% for domestic uses, and the balance of 8% for tourism and industrial purposes.
So the primary business opportunities within the water and sewerage sector. The government in the 2000 had a national water policy which introduced private sector participation. I understand that the draft water policy for 2015 also continues that approach. NWC revenue as a service efficiency of 31% was 24.167 billion in 2013-14. At 70% it should be about 55 billion. So in essence, there's a business opportunity of about $30 billion that could be obtained by simply increasing the efficiency from 31 to 70.
With its 2030 goal of all persons having access to a safe and reliable water supply, the government of Jamaica is also considering service areas such as water supply, wastewater management, irrigation, and flood control. Other initiatives include developing local catchment facilities, building a culture of rainwater harvesting, as well as responsible and efficient water use, developing more extensive sewage recycling, implementing cost recovery systems, reducing energy costs and diversifying sources, implementing a rural water supply strategy, providing sewage services, continuing to follow an integrated water resource management approach, and planning for climate change adaptation. With terms like green tourism and ecotourism, the tourism sector accounts for 40% of the foreign exchange earned and in excess of 11% for GDP. The scoping study determined that a green tourism strategy will mean increased size and diversity of the tourism workforce as additional and more specialized skills are mobilized to ensure new green standards in tourism entities.
Dealing with educating the hotel sector about sustainability actually gives you an opportunity to look at just about every sector and section and personality that you might have to deal with. And what we have learned is there are technologies available, there are options and opportunities. We are in the information age. There's whatever you want to do, there's an app to do it. However, if you don't bring the basic reason, the why of your green economy and your green drive to the staff and to the people who are actually going to do what needs to be done, you will find yourself dead in the water before you realize you're in the water.
Jamaica's leading hoteliers are more sensitive to the value of a healthy environment and the need to reduce the cost of energy through conservation and the use of renewable energy sources. The study outlines a number of strategies for this industry as well. These include promoting and incentivizing renewable energy use and water use reduction, planning for sea level rise and the other impacts of climate change, developing and implementing branding and marketing strategies emphasizing green elements of tourism, providing green investment incentives, promoting investment in and providing incentives for small, medium, and micro enterprises, and leveraging public-private partnerships. The scoping study recommends that government sends the appropriate signals through policies and regulations that incentivize green investments while disincentivizing brown investments. The aim is to guide private and public consumption away from practices that are harmful to both public health and the environment.
Also, what was important was the management of human and social capital. You can't grow an economy without well-educated, qualified, technically qualified, and otherwise qualified people. And one of the big problems in moving countries towards a green economy was a shortage of people who could do the job. Whether it be adopting green technology or whatever it might be, there was a shortage of people, and not necessarily a program to train those people.
Now, construction industry, to go to a global view now, it really affects many of the Sustainable Development Goals, including Goal 6, water, Goal 7, energy, Goal 8, jobs and economic growth, 9, infrastructure, 11, sustainable cities, and 13, that we overall protect the planet.
Ultimately, the success of greening the economy will depend on the profitability of green investments and creating solutions by aligning the goals and interests of all stakeholders.
Me have to protect him. That's why I put a code in the cable box so him can't access any adult or X-rated channel. It's me choose to put the cable in the house, and choice come with responsibility.
Broadcasting Commission. More choices, better access, and higher quality.
When the devil knock you down and knock the living breath out of you, and you ain't got nothing else to do but to get down on the floor and say, God, I call upon your name today. If you don't help me, God, help.
Stand in God's power with Henry Fernandez this and every Sunday at 7:30 a.m. with a repeat at 8 p.m. on PB.
Light, and all of a sudden, whatever he said, light. Oh, I dare you to open your mouth, and whatever you want out of life, open your mouth and say it. Say it. Say it. And it will be so. Somebody ought to give God praise again.
Follow God's plan for your life with the teachings of Henry Fernandez, Sunday morning at 7:30 with a repeat the same evening at 8 p.m. Only on PBCJ, the People's Station. Unfolding events affecting our country are not always obvious. You have to be at the point where the issues are debated and decisions taken. The Senate proceedings on PBCJ with host Simone Absalom puts you ringside as our leaders debate the issues affecting our island. That's the Senate, Fridays at 10 a.m. with a rebroadcast 9 a.m. on Saturdays. The Senate on PBCJ, the People's Station.
And despite the
This Honourable Senate now resumes its sittings. May I just indicate that we have a custom really to sit on a Friday, and I know that we have had a number of sittings on Thursday, and I just wish to extend my gratitude to the members on both sides who no doubt have had to make some adjustment to their personal schedules to be here, to do the nation's business, and I thank you all for the adjustments that you have made to ensure that we can participate and get through some pressing business. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following. White Paper Number 1 of 2016 entitled National Identification System Policy for Jamaica. Ministry Paper Number 108 and Annual Report for Financial Institution Services Limited for the financial year ended March 31, 2016. Ministry Paper Number 109 and Annual Report for Financial Sector Adjustment Company Limited for the year 2015-2016. Ministry Paper Number 110 and Annual Report for Jamaica Deposit Insurance Corporation for the financial year ended March 31, 2016. The Insurance Amendment of Schedules Regulations 2015 dated November 2, 2016. Jamaica Mortgage Bank Annual Report and Audited Financial Statements for the year 2015-2016.
Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives to the Honourable Senate. I have the honour to advise the Honourable Senate that on Tuesday, November 8, 2016, a bill entitled An Act to Amend the Proceeds of Crime Act was passed in the House of Representatives. I also have the honour to advise the Honourable Senate that on Wednesday, November 9, 2016, the House of Representatives agreed to the amendments made by the Senate to a bill entitled An Act to Amend the Criminal Justice Reform Act, the Child Care and Protection Act, the Corrections Act, and the Parole Rules 1978 in order to provide for the use of restorative justice procedures as an option in the criminal justice system. Signed, Pernell P. Charles, CDJP MP, Speaker of the House of Representatives.
Mr. President, I signify my willingness to take charge of the first mentioned bill.
A bill shortly entitled The Proceeds of Crime Amendment Act 2016 read a first time.
Mr. President, I beg to give notice of second reading of the bill, and I also beg to give notice that at a later stage today, I will move for the suspension of standing orders to enable me to take second reading of the bill and to take it through its concluding stages.
Petitions, reports from committees, notices of motion given orally.
Mr. President, I beg to give notice that at the next meeting of the Senate, I will move that whereas subsection 1F1 of section 41 of the Constitution of Jamaica requires a member of this Honourable Senate to vacate his seat if he becomes a party to any contract with the Government of Jamaica for or on account of the public service, and whereas subsection 1G1 of section 41 of the Constitution of Jamaica requires a member of this Honourable Senate to vacate his seat if any firm in which he is a partner or any company of which he is a director or manager becomes a party to any contract with the Government of Jamaica for or on account of the public service, or if he becomes a partner in a firm or a director or manager of a company which is party to any such contract. And whereas Senator Floyd Morris may from time to time enter into individual contracts as well as contracts in his capacity as manager of F.E. Morris International Consultancy Services, a trading entity, with the Government of Jamaica and its agencies for and on behalf of the public service. And whereas Senator Floyd Morris has disclosed his individual interest as well as his interest in his entity, in this entity, be it resolved that this Honourable Senate, pursuant to subsection 1F1 and 1G1 of section 41 of the Constitution, and in recognition of him having disclosed his interests, exempt the said senator from vacating his seat for reasons as aforesaid. And Mr. President, I further beg to give notice that at a later stage today, I will move for suspension of the standing orders in order for me to take this motion.
Questions and answers to questions?
Mr. President, I'm seeking your permission to answer the questions posed by Senator Morris today in lieu of the fact that the date that was scheduled for the answers to be given would have been tomorrow, November 11th, and I'm seeking your leave, sir, to provide the answers earlier. That is today.
Senator Morris.
Yeah, I'm saying that I was aware, I wasn't informed that the questions would be answered today, and I would have liked to get a copy, an electronic copy of the response so that I can follow the responses that the minister is presenting.
Senator Morris, if it is that you wish us to have the minister send the answers to you in a form that you can analyze them more carefully, and then we take it on another date, I don't think there would be an issue.
Well, I wouldn't.
We can take it at the next meeting.
I wouldn't have a problem with that approach as you have suggested, Mr. President.
Yeah, what I'm going to do is ask the minister to table the questions, send it to you electronically, and if it is that there are follow-up questions, then you can ask them on the next occasion, if that's okay with you. Does that find favor with you, Senator Morris?
Yes, Mr. President.
So Minister, you will table the answers to the question, and then on the next occasion make yourself available to be cross-examined by Senator Morris.
Mr. President, I would like to formally give notice that the questions that is referred to on the other paper yeah, both of them, both 5 and 6, both questions 5 and 6.
Standing in the name of Senator Morris.
Standing in the name of Senator Floyd Morris, that I am therefore moving to table the answers to those questions.
Thank you, Senator Reid. Motions that may be made at the commencement of public business requiring notice. Motions relating to sitting of the Senate. Motions for leave to introduce bills. Presentation of bills without the leave of the Senate first obtained. Public business.
Mr. President, today it is intended to take the Jamaica Agricultural Commodities Regulatory Authority Bill through its concluding stages. We also intend to move for suspension of standing orders in order to take the Proceeds of Crime Amendment Bill through all its stages. And we wish to first, however, ask the Honourable Minister of Education, Youth and Information to take the reports standing at items 7 and 8 in his name. And I will first, however, move for suspension of standing orders to enable me to take the motion, notice of which I gave earlier.
The question is that the standing orders be suspended in order to allow the minister to take the motion, notice of which she has given earlier. Those in favor? Against? Proceed, Minister.
Mr. President, I now move that the motion, notice of which I gave earlier, be agreed to.
The question is that the motion which the minister had moved earlier be agreed to. Those in favor? Against? The ayes have it.
Mr. President, I'd like to move that be it resolved that the report of the Regulations Committee of the Senate on its deliberations on the National Housing Trust Housing Benefits Special Selection Longville Housing Development Phase 3 Order 2016, which was laid on the table of the Senate on the 28th day of October 2016, be now approved.
So you're dealing with the first motion. The question is that that motion be agreed to. Those in favor? Against? The ayes have it.
Mr. President, I wish to further move that be it resolved that the report of the Regulations Committee of the Senate on its deliberations on the National Housing Trust Housing Benefits Special Selection Balaclava Housing Development Order 2016, which was laid on the table of the Senate on the 28th day of October 2016, be now approved.
You have heard the motion. Those in favor? Against? The ayes. Minister?
Thank you, Mr. President. It's now proposed to close the debate on the JACRA bill. In so doing, I'm going to, Mr. President, outline the more substantive issues which were suggested and which we have taken on board, briefly mention a few which we have determined will not be addressed or taken on board in this bill.
Could you just, for the record, just indicate where it is we have reached with this? Because there was a debate, and I think that you had suspended the debate subject to some instructions. Would you just, for the record, indicate where we are with it?
Yes, Mr. President. The intention was that today I would close the bill and take it through its remaining stages. Close the debate, pardon me, and take it through its remaining stages. So the list which, the order in which I'll address the issues won't faithfully follow the list, but the list of amendments, but the list that we're working with and the list that will guide our discussions in committee is the hard copy list that was circulated at the last sitting when we had intended to address this bill.
For the record, that the date was the 14th of October.
No, there was a version circulated on the 3rd of November.
Okay.
And that is the document which we are working with.
So the debate started on the 14th?
Yes, it did. Thank you, Mr. President. Mr. President, I wish to, of course, ensure that I sincerely thank colleagues on both sides for their suggestions, for their deep thoughts that address the ways in which they thought the bill could be strengthened, and indicate that the ministry team, the technical supporting team, and the legal team really took quite a bit of time to think seriously about the issues and assess how it is that we could strengthen this bill. And I think the amendments that have been circulated will do justice to this improvement to the industry and to the agricultural sector as a whole. Mr. President, one of the first matters which we took on board was the clarification of the term commercial significance. We will be setting out thresholds for this very important item, as it does impact an understanding of how the bill is intended to operate and how it can be enforced. It affects matters as fundamental as licensing requirements, and therefore these thresholds will form part of Schedule 5 to the bill, and in this way they can be addressed more easily if that is necessary down the line as commercial production and development of the industry develops. Mr. President, these thresholds were established in consultation with the heads of the existing industry boards, and based on an understanding of how the industries have operated over the years, as well as, in certain circumstances, mathematical calculation of what agronomists, how agronomists define a household and the domestic consumption within a household, and that those numbers, for example, a household comprises 6 persons, each drinking a cup of coffee, what yield would contribute to the 6 cups of coffee, and they're multiplying that by 2 in order to give wriggle room for a small cottage industry or a community-based production. And that is the basis on which they have been established and included in this bill. Mr. President, in respect of licenses and the licensing regime, the bill will now clarify the requirements for a license under this Act. For example, we will make it quite clear that farmers will not need a license to grow these commodities if growing is all they do. And farmers growing in commercially significant quantities, however, will be required to register with JACRA. So this is to enable the body to know who is growing, where the crops are located, so they know where technical advice is needed and where support is needed and can be supported. But this will be a simple administrative process and will not include a fee. So if you're growing, to be clear, and this is to ensure that the scheme doesn't act as a constraint or any discouragement on actual growth and production, because of course you might start small and expand, or you might grow small and pool your resources as well. And we want to encourage that type of activity, but we also want to balance the need for information and to regulate. So to be clear, if you grow just for household consumption or for small community-based sale, you won't need a license and you won't need to register. But if you're growing in commercially significant quantities, then you will need to register. Simple administrative process, as I mentioned. But if you're operating a nursery, which is growth in a sense, and if you're growing in addition to undertaking commercial activities which require a license under the bill, then you will require a license for those activities as a matter of course, and the fact that you are growing won't exempt you. So I hope that that is clear, and in committee, if members have questions, then we could certainly clarify at that stage. And those matters are dealt with under 14, 15, and 16, which deal with the regime, licensing regime and its exemptions. In respect of term and renewal, Mr. President, we have also taken on board that license should be offered for a longer period than the original 1 year provided for. The new period is 3 years, and licensees will have the option of paying in 3 equal installments at the time of the grant and on the subsequent anniversaries of the granting of the license. We have not, however, taken on board the suggestion that a period longer than 90 days is required for notice of renewal. That we think is more likely to institutionalize inefficiency. And there's nothing particular to this application process that should require more than 90 days. Mr. President, in respect of refusal to license, we've taken on board concerns expressed about the scope of previous convictions which would enable JACRA to refuse a license. As such, they've been narrowed to include serious offenses concerning fraud, dishonesty, moral turpitude, and offenses, again, serious offenses under the Dangerous Drugs Act, rather than including any offense against this act or the regulations. So also, the number of years contemplated between conviction and the application for a license has been reduced from 5 years to 3, and this has been applied across the board for individuals and directors of corporate entities to ensure that there is a balance between the requirement to ensure that we have a clean and well-regulated industry based on farmers, importers, exporters, and general stakeholders of integrity, with the need to ensure that agriculture remains open as a profitable venture for young persons who may have made wrong turns in their lives. The ministry has also specifically taken the position that the use of abusive language to an inspector albeit improper, should not be a punishable offense under this bill. Mr. President, in respect of suspension of licenses, we have proposed amendments to make it clear that suspension of a license should not take effect until the period specified for remedying the breach, where a breach is capable of being remedied, and that clarification is an amendment also included in the list of amendments circulated. So the suspension will not take place unless that time and until that time has elapsed. Mr. President, on the matter of the appointment of the Director General, we have made it clear that the appointment of the Director General is mandatory. We have also addressed the request for greater clarity on the qualifications for the post of Director. So the proposed amendments now state that the Director General shall possess the knowledge, skills, and experience which are required for him to perform, for him or her, to perform the intended functions under the bill. And those functions, of course, were already set out in detail in the original bill. Mr. President, it also states expressly that he shall be a person who is able to exercise competence, diligence, and sound judgment in fulfilling his functions, and be a person of integrity who has not been convicted of any offense involving fraud, dishonesty, or moral turpitude. Mr. President, in respect of confidentiality, we have adjusted the approach, creating exceptions to the secrecy obligations so that disclosure can be clearly permitted in certain circumstances, disclosure to a court, registrar of companies, and in respect of requests made under the Proceeds of Crime Act in respect of any crime, etc. And those are, of course, outlined in the list of amendments which had been circulated. In respect of appeals, Mr. President, the Ministry has also agreed that the Minister should not be burdened with appeals from aggrieved persons, but rather be free to deal with matters of policy. And in this regard, it is proposed that an appeal tribunal, to be named the Regulated Agricultural Commodities Appeal Tribunal, be established. So the proposed amendments sets out a new Schedule 7, which addresses matters of the composition of the tribunal, the procedure of hearings, and the powers of the tribunal. And just briefly, Mr. President, the tribunal will consist of at least 3 members appointed by the Minister, one of whom shall be an attorney at law who has practiced for at least 10 years, and the other members shall be selected from persons who appear to the Minister to be qualified as having experience in matters related to agriculture, industry, finance, economics, accountancy, commerce, or law. In respect of procedure, Mr. President, the schedule sets out that appeals shall be brought to the tribunal by way of notice of appeal by a person aggrieved by a decision of the authority, and such appeal shall clearly set out the grounds of the appeal and be brought within 21 days of receiving the decision from the authority. The tribunal shall, Mr. President, among other things, cause all parties to be informed of the date of the hearing of the appeal, and the tribunal shall hear each matter and give its decision in writing within 90 calendar days of the filing of the appeal. In respect of powers, Mr. President, the tribunal will have 3 powers. It may dismiss the appeal and confirm the decision of the authority. It may allow the appeal and set aside the decision, or it may vary the decision. Mr. President, in respect of penalties, this administration agrees with retaining the alternatives for general administrative or minor offenses, so that a penalty may be established as a fine and, in default of payment, imprisonment, and either or circumstances for general offenses. But we have taken the position that in light of the seriousness of predial larceny and other serious offenses which are likely to have specific commercial and pecuniary benefit, that in those circumstances that we will retain the opportunity to have a fine and custodial sentence stipulated. Mr. President, in respect of restitution, the amendments provided expand the provision dealing with a restitution order against the offender in favor of a victim to require payment equal to the value of the regulated agricultural commodity that has since deteriorated, perished, or is no longer of merchantable quality. Additionally, in the case where the victim is deceased, it is being proposed that the proceeds of an order of restitution inure to the benefit of the victim's estate. And the concern that was raised in respect of the role of the prosecutor has been addressed in this new formulation. It's been removed. Mr. President, in respect of service of notice in forfeiture applications, which was also an issue raised, the Ministry is in agreement that service of a notice of intention by the authority to apply for forfeiture of regulated agricultural commodities should be done by way of personal service in the first instance. And it is then, if this is not possible, that other methods of service will not be precluded. Mr. President, in respect of the vesting of merged assets, the question had been raised, how will the assets of the existing entities be addressed? And that is set out in Section 40, in Clause 40 of the original bill, which states that all the assets will vest on the passage, on the entry into force of the Act. But, however, the amendment to the bill will now propose that in relation to the assets of the Cocoa Industry Board, which, and in particular, the Richmond Cocoa Fermentary, the Morgan's Valley Cocoa Fermentary, and the cocoa farms owned or operated by the Cocoa Industry Board should not be vested in the authority. And that is because there is a divestment process in respect of those, an active divestment process in respect of those assets, and accordingly they will not form part of the automatic vesting provided for under the bill. Mr. President, in the schedules, I can assure that the provisions in respect of guarantees will be deleted because those are properly already addressed in Section 17 of the Public Bodies Management and Accountabilities Act. So they have been removed, they weren't required. In respect of the board and proposals that were made in respect of its composition, we have agreed to broaden the composition to include the skill sets, expressly include the skill sets of law, finance, and human resource management. And the ministry has also agreed to specifically state that both ex officio and appointed members have a vote. A provision has also been proposed in respect of the nominated members of the board, the industry nominations, that is. A provision has been proposed so that where a body appearing to the minister to be representative of an industry fails or refuses to nominate a representative within 28 days after the minister requests that body to so do, or where no body appears to the minister to exist, the minister may appoint such person as he believes fit to the board. In respect of matters which were considered but not adopted, the matter of immediate suspension of licenses due to matters of disease outbreak. The ministry believes that this matter, that is disease outbreak of plant material, falls within the purview of the ministry's plant quarantine division, which is a competent authority that administers the Plant Quarantine Act. And therefore, those matters should properly be dealt with there as they provide an urgent and stringent response to disease identification and eradication. So there would be no need to duplicate responsibilities here. In respect of concerns raised in regards to tax exemption, JACRA will be a regulatory body that is not profit-making in nature, and it has been determined as a matter of policy that as it won't be able to carry out its functions effectively or be sustainable if it is subject to taxes, because the cost of the tax regime would also, of course, run on to the fees which it would need to pass on to farmers and therefore cause a cycle, an undesirable cycle. The ministry has taken the position that JACRA should remain exempt from income tax, stamp duties, transfer tax, and customs duties. There were mentions made of inclusion of climate change, food security, land utilization, and crop insurance, and it was felt that those matters were not appropriate for inclusion in this bill, some for obvious reasons. In respect of the final concern that was raised in respect of the creation of monopolies, certainly there is no mechanism within the new efficiencies to be achieved by merging these bodies that is likely to create a change to the market structure. So we felt that that matter would be misplaced for consideration here. And with that said, Mr. President, I ask that, there are just 2 points that I wish to point out in respect of the list of amendments. There have been 2 adjustments to the list of amendments before I formally close the debate. In clause 2 on page 1, there is a new item 6, which reads, in the definition of nursery, insert next after the word commodity, the words in commercial quantities. So we will be, inserting a new 6, where's nursery? A new 6, and renumbering 6 to become 7. No. In clause item on the list of amendments, which I believe I had said, on page 1 of the list, we will be inserting a new 6, which is what I just read about the definition of nursery, and renumbering the existing 6, which addresses regulations, as 7. The amendment, or the new item 6, under clause 2 will read, in the definition of nursery, insert next after the word commodity the words in commercial quantities. Also on page 2 of the list of amendments, which address clause 9, under subclause 2, paragraph C, which says appears to the minister to be a person of integrity, we will be deleting the word minister and replacing it with the word board. So again, that's clause 9, page 2, in fact, sub 9, subclause 2, subparagraph C. We'll be changing the word minister to board. And with that, Mr. President, it's my pleasure to close the debate on this bill, to once again thank my colleagues for their suggestions to improve the strength and operation of the bill, and ask that we now move to enter into committee stage. I move for second reading of the bill.
The question is that the bill be read for a second time. Those in favor? Against? Ayes have it.
A bill entitled An Act to Establish a Body to be known as the Jamaica Agricultural Commodities Regulatory Authority for the development, regulation, promotion, and standardization of the agricultural commodities industry and for connected matters, read a second time.
The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. So I put clause 1 of the bill. Those in favor? Against? Ayes have it. I put clause 2. I'm sorry, there are amendments to clause 2.
The first comment, in the new definition of license, there's no reference in it to a certificate of registration applied for by a grower. And that appears, I just want to make sure that that's a deliberate omission, because there's a new concept, I think. I'm sort of trying to identify which is the latest list of amendments, because there are no date stamps on them. but I believe that there is a new reference to the concept of a certificate of registration in relation to growers who grow a commercially significant quantity of goods, of regulated produce. I'm just making sure that the definition of license is not intended to include that, because the way license is defined as a license, import permit, export permit, or other authorization could arguably, the idea of an other authorization, which appears to be a catch-all phrase, could arguably include that. And I don't think, from what you've said, the intention is really to ensure that growing is not a licensed activity. So I would ask that that be made clear in the definition of license.
Thank you, Senator. We think it is actually quite clear because it doesn't, the catch-all speaks to other authorization granted under Section 17.3A, which is specific in its scope. As I had explained, the intention is to allow for a certificate of registration to be granted, and that's under 15, under clause 15, in respect of growing only. So that is not something that's dealt with under 17.3A. So licenses there's a licensing regime that requires an application fee, a licensing fee, a term of 3 years, and certain requirements to be met. If you are growing, however, and that of course relates to the activities which are conducted under 14.1. Growing specifically only requires, and growing in commercially significant quantities, only requires a certificate of
I hear you,
registration.
but I'm not yet satisfied with that answer, because there is no provision in the bill that I've found that deals with the process for issuance of certificates of registration. There's just a reference to it in a new subsection that says that a grower who's growing more than a commercially significant quantity is required to have a certificate of registration. The scheme of the bill is that the issuance of these things, licenses with this broad definition, is dealt with by 17.3A, as you pointed out.
Yes.
But there's a gap in relation to these certificates of registration.
Not really, because under clause 15.3, which is, and the amendment is found on page 5, right in the middle of page 5, it says that every person who grows or intends to grow a regulated agricultural commodity in a quantity that is of commercial significance shall apply in the prescribed form and manner to the authority for a certificate of registration.
Yes.
And this will be prescribed.
I hear you, but the issuance of this certificate and the power to issue it is not addressed in any enabling provision in the bill. And if you look at 17.3A, that is the enabling provision that grants the authority to the authority, the power to the authority, to grant licenses. Anyway, this discussion, with the benefit of hindsight, may help any puzzled reader of this legislation, if they care to do the research, to be clear that the licensing regime and the way in which license is defined is not to include certificates of registration. I would have preferred that to be clear in the definition of license. I think that would be beneficial. I think not to have it is a deficiency in my own view, though I know others may not share that view. But I think it's important that this has been recorded, because that will be the interpretive tool that if this matter ever gets litigated. The other point I wanted to raise is in the new provision that was referred to by the minister in her closing of the debate, the new inserted item 6 in the list of amendments to clause 2 makes reference to commercial quantities, I believe. And that I don't think is a defined term. We have commercially significant is defined, and again, in a somewhat unwieldy way, because we have the same phrase meaning two different things in two different contexts, but we can live with that. But we're using a phrase here, commercial quantities, which is not defined. And I think we should, if it's intended to have the same meaning as commercially significant in relation to crops, then Part B of the new fish schedule will apply. If it's meant to have the meaning ascribed to products made from crops, then Part A of the fish schedule will apply if we use the word commercial significance and we tie the fish schedule to this provision as well. But currently, it seems to be untied.
That's corrected by using the term commercially significant, and then it all works together because it will tie in with the growth. Clearly, the nurseries are growing, and if you're growing,
so are you
then
proposing
it's
to use commercial significance?
Yes, absolutely. That's an error.
It's an error, is it? Okay. And just to point out that the way in which commercially significant is defined is not a general definition for the purposes of the bill as a whole, but is limited to the specific two particular provisions, which are 16.1b and 16.2. So it's not, for example, the references don't include 15.3 where the phrase is used, or this item in clause 2 of the bill. So that needs to all be tied together so that the definitions apply as they should. Yeah. You may want to just move on and we come back to that when they've had a chance to. Yeah.
Okay, so, Okay, so I suspend the considerations on Part 2, clauses 3 to 13, and I put Part 3, clauses 14 to 27.
Wait, no, we're in clause 2, sir. Just put clause 3, please.
You're going... Okay. So look here.
I know you're in a hurry. Mr. Chairman, the amount of amendments to this bill are as voluminous as the bill itself. So we can't rush it. We need to make sure we get it right, because the House didn't.
Senator Golden, it's not a problem. I'll go clause by clause. No problem.
Thank you, sir.
All right, so I'm now suspending the debate on clause 2, and I will move to clause number 3.
Yeah.
There are no proposed amendments to clause 3.
So those in favor?
So I put clause 3. Those in favor? Against? I put clause 4 of the bill.
Mr. President, there is an amendment to clause 4, and it is to be found on the bottom of page 1, at the end, rather, of page 1 of the list of amendments proceeding to page 2, where the first matter addresses clause 1, the deletion of paragraph F, and substituting therefore as paragraph F the words subject to subsection 2, comma, grant licenses, semicolon. And further, the second amendment would be in subclause 2 of clause 4, where it is proposed to delete the word permits and substitute therefore the words import permits.
Right. So again, certificates of registration, the issuance of those are not currently covered by this. I just raised it because I feel in clause 2 it should be clear what license does span and doesn't span.
For avoidance of doubt, I would want to suggest that we seek to address that here. That is, address it in subparagraph F. So it would be subject to subsection 2, grant licenses and certificate of registration. If that could be considered. If you think it should go elsewhere, but I'm asking the technical team to just consider addressing it there.
So what does other authorization imply?
It's playing the role of a catch-all, because we talk specifically about import and export permits and licensing, but they have these other authorizations. And then they have this concept of certificates of registration, which doesn't really tie in. So we're just trying to make sure that that's addressed. One point, Mr. Chairman, if I may, I had suggested that in this list of functions of this mega regulator, which perhaps in the future may even become more mega if we add other agricultural commodities to it, there is no reference to promoting growth and investment in the industry. And in a sense, that's to me, especially in the context of the agricultural industry, those are important considerations in terms of the way in which a regulator approaches their job. It sends a signal. And I know both sides of this aisle are very much in favor of growth. You know, we have laid the platform, and the seeds that we have sowed are now budding, which we're all very happy about. Yes. So I thought that in keeping with that fact, it would be useful if we could have, it would be useful to me, if we could have included in 1A or 1B some reference to the promotion of growth and investment, or investment and growth because you see, if a regulator doesn't have that, regulators tend to be often inimical to growth issues. Certainly in other sectors, those of us who have practiced, you have worn another hat in the past, and I have as well. And yes.
Chairman, I agree, but I would only suggest that it should be a standalone, allow it to be more substantive, rather than have it subsumed in an A or a B. Another paragraph.
I think the ministry actually considered this matter, and as a matter of policy, it was determined not to include it. It is a different role. There is an accepted role of government to encourage growth, and there are various streams of activity which will promote and support investment and growth in agriculture and identify areas of strategic importance, such as the new regulated agricultural commodities. But it was felt that the functions of this body are quite clearly well defined and balanced as a regulator, and it's not thought at this time appropriate to include that.
I have heard those ideas and that approach articulated in other contexts by regulators. Even the Bank of Jamaica, achieving full employment within the context of monetary stability is considered to be part of their role. So I think any regulator, especially in an undeveloped economy like ours, needs to have a view of its role as being one that regulates, yes, but in a context of trying to achieve the macroeconomic objectives of the society. And if you don't put that in here, they are creatures of the law like any other bureaucracy. And if you don't send that signal, they're not going to take that philosophical outlook. They're going to have a narrow view about ensuring that these people are paying their fees and are, and not violating any regulations and so on, which is very important. But it's also important that at times they're prepared to take a broader view of things. And if the signal is in the legislation, then you can always appeal to them on that great basis. If it's not, you have no basis in law to do so.
There would be clearly an argument to say that promoting interest and efficiency, I'm not sure if, I don't think any harm would be done by saying growth, interest, and efficiency, but I think starting to craft language around a standalone clause, I'm not sure I would go down that path, given that the minister had not seen that it was necessary to improve it. So if you're satisfied with the one word, then with inclusion, then we can
I would love you to say investment as well. Promote investment, growth,
no,
interest,
I think
and efficiency.
promotion of investment is a different category of activity as well.
You can't really have growth without investment.
Well,
but anyway.
So, Minister, you are proposing to promote growth, or interest, growth, and efficiency?
Yeah, I think that would be the right formulation, Chair. Interest, growth, and
promote
efficiency.
Interest, growth, and efficiency. a comment on the subsection F that you were looking at?
Minister, are you okay with the formulation that the chairman suggested? Interest, growth, and efficiency? Yeah.
We are amending clause 4.1.
4.1a, right?
4.1a. We have already been through 4.1f, and we were waiting to hear if that was an appropriate place to address the matter of certificates of registration. But they have decided that that is not where they will suggest it, so we could perhaps take clause 4, Mr. President, as amended.
So I take the amendments to clause 4 in favor.
And just to clarify, by that we're talking about an amendment to 4.1a to insert the word growth, a common growth after interest, and also the other amendment on the amendment sheet. That's what we're doing. All right. Thank you.
So I put the amendments to clause.
To be clear, also subparagraph F and subclause 2.
Yeah.
So I put the amendments to clause number 4. Those in favor? Aye. Against? And I now put clause 4 as amended. Those in favor? Aye. Against? I put clause 5 of the bill.
5 to 8.
Put 5 to 8.
5 to 8. Could put 5 to 8.
We could take 5 to 8, Mr. President. There are no amendments. 5, 6, and 8 is fine by me.
So I'll put.
To be my most accommodating self today, Mr. President.
So I put clauses 5 through to 8. Those in favor? Against? Ayes have. I put clause 8 of the bill.
Clause 9.
I'm sorry, I put clause 9.
Mr. Chairman, there's some concerns that 9, and I want to suggest an amendment to the amendment. I note the clause, it's deleting the existing clause and to replace it with this amendment. Maybe we can find easy agreement on the first one, that at 9.3, it should be section 2, 3, and 4 of clause 11 rather than section 11. I think we can agree on that.
Will become section. So the
Section
word should
11
say
rather
section.
than clause 11?
Yeah, yeah.
Right.
We call it, the provisions in the bill are called clauses when they're in Parliament, but the text refers to them as sections.
Right. In terms of 9.1, Mr. Chairman, it's not the intention, as I understand it, to give the board unlimited authority to set the terms and conditions of employment. And I noticed that clause 9.3, addressing ancient and convoluting language that the ordinary people does not understand. A proposal to import from clause 11 a provision which says the board does not deposit the authority that 9.1 purports to give it. I'd like to propose that after the words at 9.1, as the board deems appropriate, the following words: after approval from the minister with responsibility for the public service. That would eliminate the need for clause 3, which asks us to import from clause 11 terms, in terms that, I don't know it's going to be a lawyer, but it's only lawyers who really understand this Latin phrase here. And I think we must move towards making our legislation simpler and user-friendly, rather than asking this Director General or the board to go and look now and get a lawyer at the expense to explain what clause 3 means, when it can be resolved by the words I propose. After approval from the minister with responsibility for the public service, and that would solve the problem.
It wouldn't. Thank you for your suggestion. Thank you for your suggestion, but I'm not persuaded that this would be the best approach. I think that the structure follows properly, and I think that if we have appointed appropriate persons to the bill, they should have no difficulty with understanding what mutatis mutandis means. We have changed the scope of persons who should be appointed, and they should be persons who are knowledgeable in areas of management or law, etc., human resource management. This is a clause which would need to be consulted by persons such as the Director General or managers, and I don't think that there should be any challenge with having that there. Furthermore, your reference to the Minister responsible for public service would only address Clause 2 and subsections 3 and 4 have also been imported to ensure that there are appropriate provisions in respect of the authority of the Governor General and the terms on which the rates may be set. For the Director General, yes. Oh. No, the Governor General is referred to in this clause as well. So, but thank you for your suggestion. And
yeah, I mean, I can see the point that was being made about the scheme of it is complex, because when you read it, it starts by saying that the board should appoint a Director General of the authority at such remuneration and such terms and conditions the board deems appropriate. So on the first blush, it's an open canvas as to the salary that the person is to be paid, but it's subject to subsections 2 and 3. When you go to subsection 3 then says subsections 2, 3, 4 and of 11 apply mutatis mutandis, which are the words that Senator Brown is concerned about, to the Office of the Director General. So you are then shunted to yet another provision where you have to read to see that, in fact, when you turn the page, that this is subject to whatever limit may have been fixed by the minister responsible for the public service. So the structure works, but it's a little cumbersome.
I think that's the point. It works, and I think where we are in terms of the amendment, while it may not be your best preferred structure, it works. Yeah. It makes sense, and it has been reviewed. And if I don't want to tweak it on the fly and end up creating problems that we didn't anticipate, having already taken the time.
I understand, but I accept that.
Really ask that we
but I just wanted to make one comment on the use of Latin phrases in legislation. I think we need to take a decision within the Ministry of Justice and the broader government that in drafting we find other formulations that have that meaning. So my understanding of what mutatis mutandis means is with such changes as may be required. You know, that formulation in plain English could be used as a way of avoiding using Latin phrases. Latin is no longer taught in schools here and is no longer taught in schools in most countries. And it's a useful shorthand way of signaling what those words mean, but for most people reading it, they will have no clue what it is, and they're going to have to. So I'm just making a call to the drafters that going forward we try and minimize or eliminate the use of arcane Latin phrases in our legislation.
And beyond your call to the drafters, I will speak to the Minister of Justice about that.
In terms of 9, I'm finished with that. Point has been made. The Director General, the legislation have no time frame for tenure, and it doesn't address how the Director General may be separated. And in this season of regular separation, we've seen numerous heads of agencies separated recently. I'd like to, I think about 15 at least, heads of agencies separated. I'd like to recommend that a clause be there which addresses the termination, that the Director General can only be terminated by reasons of resignation, breach of contract, failure to perform, or disciplinary action. It shouldn't be that we just, heads of agencies, are removed, more so after change of elections. We should have some continuity. Senator Johnson Smith
consistent with the corporate governance framework that you championed so much when you sat in this seat that I am sitting in. And we really would wish that the continuity which is intended be applied to the Director General here and, of course, other heads of agencies so that what we have seen in recent times doesn't reoccur.
Thank you for your suggestion, but those are certainly matters more appropriately addressed in contract, and that is generally how they are treated for positions such as DG. But thank you for the suggestion. Mr. President, if we can put Clause 9, the amendment to Clause 9.
So I put the amendments to Clause 9 in favor. Ayes have it. I put Clause 9 as amended. Those in favor? Ayes have it. I put Clause 10.
Yes, there are no amendments proposed to Clause 10, Mr. President.
So I put Clause 10. Those in favor? Against? Ayes have it. I put Clause 11.
Mr. President, there are amendments to Clause 11 that are set out at the base of Clause 2, proceeding of page 2, of the list of amendments proceeding on to page 3. They amend subclause 1 by deleting the words officers and employees and substituting the words officers or employees. Subclause 2A by inserting immediately after the word officer the words or employee. And in subclause 5, deleting the word qualification and substituting the word qualifications. Just for editorial. Those are the amendments to Clause 11, Mr. President.
So I put I put the amendments to Clause 11 in favor. Ayes have it. I put Clause 11 as amended. Those in favor? Against? Ayes have it. I put Clause 12.
Mr. President, on page 3 of the list, there is one amendment to Clause 12, and this calls for the deletion of the word minister and substituting, therefore, the words minister responsible for the public service in consultation with the minister.
Mr. Chairman, just for clarification, just to make sure that in 12, the bottom paragraph is intended to govern A and B. The way it's formatted.
Sorry, you're not addressing what the minister just.
No, that's
okay. That's okay.
Yeah, that's fine. Yeah.
So
just the formatting of the clause, the way it's formatted in the printed bill suggests that the paragraph at the bottom is part of B, whereas my reading of it suggests that it should really go back to the margin and govern both A and B. And I think these things can have a significant impact on the interpretation of a provision, and it's important that that be clear. So if that is the case, I would just ask that that be noted.
Yeah, I think that if it were disjunctive, if it were an or, then I would share your concern. But because it's conjunctive and they will have to be read together anyway, that I hear your concern, but.
No, but the point is that the closing words apply to A as well as whether it's disjunctive or conjunctive is irrelevant. The point is that the closing words are closing words that apply to both A and B.
This is a printing error, and it will go back to margin in any event.
Good.
Clause.
I put the amendments to Clause 12. Against? I put Clause 12 as amended. Those in favor? I put Clause 13.
Mr. President, the terms of the amendments to Clause 13 are set out on pages 3 to 4 of the list of amendments.
This is a completely new clause.
It's a completely new clause.
Just one question I'd have for the minister on this. Just if you could explain to me why it is that in subsection, what will be subsection 4, which is the permissive enabling provision for disclosure in certain circumstances, and there are 2 Ds in the draft I have, but I think that might have been fixed. Yeah, but the question I have is, why is there no reference to whistleblower disclosures or access to information disclosures. I just wanted it to be explained to me. In other words, I'd have thought that this list could have included disclosure that is permitted under any other enactment, for example, so that if there's a lawful basis for disclosure, and I'm not purporting to say that those two that I referred to are all, but that's why a more generic way of phrasing it, I think, would have been advantageous. But we haven't got that. We have a list which is, on the face of it, would not include those things, and I was just wondering why.
If I recall correctly, it's because the structure of those bills allow them to apply anyway. But I can wait for some additional guidance on that. So far as I'm aware, and because the matter was discussed when the clause was being formulated. If we can put clause 13.
No, I would be suggesting as an amendment, because I'm not satisfied with that answer, I am suggesting as an amendment that we include a paragraph F, which would say where such disclosure is permitted by any other enactment.
We will accept that. We'll accept it.
So if in future you could give him the suggestion that you have, Senator Brown, where such disclosure is permitted, could I get the wording for that, please?
Where such disclosure is permitted by any other enactment.
Under any other
enactment.
That's you agree to that, Minister?
So after E, we would be removing the period and replacing that with a semicolon, and thereafter inserting the word or, and then a new subparagraph F, read as indicated, where such disclosure is permitted by any other enactment.
That's okay?
Yes, sir.
So I now put the amendments.
Sorry, 1 second. I believe we could delete the or after paragraph D.
Yeah, we'll just move it to the penultimate one.
So I put the
amendment?
I put the amendments. Sorry.
Enactment.
Whether enactment or act, you have decided on enactment.
Enactment, yeah.
So I put the amendments to clause 13 in favor. I put clause 13 as amended in favor. I put clause 14.
There are amendments to clause 14, Mr. President, which start at the middle of page 4 and proceed on to page 5. And they replace the clause in its entirety. Clause 14.1 sets out the restrictions on dealing in regulated agricultural commodities and states that subject to section 16 and except under and in accordance with this act and the regulations, a person shall not A, manufacture, distribute or process a regulated agricultural commodity or its substitute, B, export or import a regulated agricultural commodity or its substitute, C, operate works related to a regulated agricultural commodity, D, establish or operate a nursery for a regulated agricultural commodity, or operate as a dealer or special coffee dealer. Clause 2 states subsection 1 shall not apply to the wholesale or retail selling of a regulated agricultural commodity that was bought from a licensee if the purchase was made in the ordinary course of business. And subclause 3 states that a person who contravenes subsection 1 commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $3 million or to imprisonment for a term not exceeding 12 months or to both such fine and imprisonment. Mr. President, if you could put the clause.
So, Chairman, just to make the point though, because I think it needs to be made, that the removal of growing from 14.1 is a major policy move, shift in this legislation, because this is the provision through which the requirement for licensing is anchored. And we have, the bill came to the lower house, brought by the minister, passed the lower house and came here, and is only being amended in the Senate, so that the whole regulatory regime is changing, so that the primary function of growing the commodity is no longer going to be regulated in the same way, and is no longer subject to licensing requirements. It's a fundamental shift, and I accept it. I'm in favor of it, and in fact, we initiated it. But I think that it's worth noting, because it's, to me, extraordinary that it reached this far to be changed so fundamentally at this stage of the proceedings.
Okay.
Thank you for that. That suggestion was made on both sides, and in concerns for ensuring that small farmers and that growth in the industry was not stymied inadvertently. That was certainly taken on board.
So I put the amendment to clause 14. I'm still a minute. So I put the amendment to clause 14. Those in favor? Ayes have it. I put clause 14 as amended. Those in favor? Against? Ayes have it. I put clause 15 of the bill.
Mr. Chairman, the amendment to clause 15, which is proposed, is set out on page 5 of the list of amendments, and it calls for the insertion after subclause 2, subclause 3, which reads that every person who grows or intends to grow a regulated agricultural commodity in a quantity that is of commercial significance shall apply in the prescribed form and manner to the authority for a certificate of registration. And this addresses the, this relates to the concern raised earlier and will be addressed with an amendment to clause 4. That is the granting of the certificate of registration. That power will be inserted in clause 4 when we revert to that section. So if we could put the amendment, Mr. Chairman.
I put the amendment to clause 15. Those in favor? Ayes have it. I put the clause 15 as amended. Those in favor? Against? Ayes have it. I put clause 16 of the bill.
Mr.
You want? Yeah, I have a couple comments on the proposed replacement clause 16. The first comment I have is in relation to the verb in 16.1, which is the word yields. If you look at the activities contemplated in the 5th schedule, some of them are focusing on the amount of commodity that's utilized in the process and not what the process yields. And I think that we ought to say utilizes or yields, because the word yields doesn't on its own really fit with some of those activities. So, yes, utilize or yields, yes. That's a suggestion I have. The other suggestion...
Don't move off of it yet. The suggestion is what?
Mm-hmm.
I want to understand.
No,
the suggestion
in subsection
is
1 of 16 on the amendment sheet, in the third line, to insert the words utilizes or yields. Yeah. The other point I wanted to make was in relation to in 4 and 5 of the amendment sheet. The definitions of commercial significance are specific to where that phrase is used in this particular section, which is section 16. So 4 makes reference to the fact that commercial significance in subsection 1b means a certain thing, and 5 says that commercial significance in subsection 2 means a something. But the phrase commercial significance is being used in 15.3, which we just read earlier, and also in the amended in the new item 6 of the list of amendments to clause 2 of the bill, dealing with the definition, I think, of nurseries or something. So I think that we need to fix the way in which the definition works. And I would even suggest you that we move the definition of commercial significance into clause 2 and define it there, since it is used in other definitions within clause 2. It is used in 15.3. It is used in 16 as well.
Mr. Chairman, if we could, sorry, are there any other comments on that clause?
Mr. Chairman, if I may, I know the definition, and I just wondered, I know that we have gone metric, but I wondered whether the words here with kilograms and grams, whether, yes, in the schedule, I'm sorry, that's the 5th schedule. And I'm only referring to it because it is referred to in clause 17. But for ease, 16. For the untrained person who has to read this, and I wondered whether it would make better practice if we were to, yes, keep it as it is in terms of the kilograms, but to put or X amount pounds, because the truth is that there still remains a significant number of our Jamaicans who use pounds instead of kilograms in the markets. I understand where we're heading as a country, but I'm saying that, you know, we have to make laws easier to understand, and I don't know if the regular person on the JUTC bus speaks in kilograms as opposed to pounds. So perhaps you could put 1,000 kilograms or 2,000 pounds.
I take your point. I take your point. So we're gone metric, and this is legislation. This is the work of the Parliament, and therefore the term that's used in there is appropriate. What I would say might probably be most helpful, though, is that in the public education that takes place and in the notices that will undoubtedly be placed in the farm stores and in the RADA outposts, etc., that the information that is circulated could possibly refer to both, but changing it in the Act, yeah, I think might not necessarily be appropriate. Yeah. We could use it in the public information where more people will interact with it than it's likely in the actual legislation.
If it's convenient to make a comment on the 5th schedule, because its genesis is clause 16, which is where we are. So
unless you have a challenge with the wording of clause 15 and 16 in terms of how it affects it.
I will just mention what my issue is, which is that, and it is a wording issue. If you look at it, and it's a small point, but I think it's important. These amounts in the 5th schedule, which constitute commercially significant amounts, are minimum amounts. In other words, that or more is what. And I just think that the way in which the 5th schedule is worded at the top ought to make it clear that these are quantities of the following amounts or greater. Yeah. Yeah.
If we can, well, I think we were looking at including in 16.1, after the word yields in line 3, the words or utilizes. But I don't recall. There's no other amendment to this clause.
I put the amendments to clause number 16. Those in favor? I put clause 16 as amended. In favor? I put clause clause 17 of the bill.
Mr. Chairman, the amendments to clause 17 are set out on pages 6 to 7 of the list of amendments. In the first amendment proposed is that in subclause 3A, the words subject to subsection 4 be deleted and substituted with the words subject to subsections 4 and 6. The next amendment is that in subclause 4A, the words 1 year be deleted and substituted with the words 3 years. The third amendment is that we insert next after subclause 5 the following as subclauses 6 and 7, which read 6. License fees prescribed under subsection 3 may be paid annually in 3 equal installments on the grant and subsequent anniversaries of the grant of the license. And 7, every licensee shall comply with the health and food safety standards specified in the 6th schedule and with such quality standards and health and food safety standards prescribed from time to time under section 37 or under any other enactment. If there are no further amendments to clause 17, Mr. Chairman.
I put the amendments to clause 17 in favor. I put clause 17 as amended. I put clause 18 of the bill.
Mr. Chairman, sorry, clause 18, the amendments appear on page 7 of the list of amendments. They first ask that we renumber subclause 1 as the clause, and in the clause as renumbered, paragraph A, the first amendment would be in paragraph C, delete subparagraph 3 and substitute therefore the following. 3, subparagraph 3, has been convicted of an offense involving fraud, dishonesty, or moral turpitude, or an offense under the Dangerous Drugs Act during the period of 3 years immediately preceding the application for a license. The next amendment being in paragraph D, 1, deleting subparagraph 4, 2, renumbering subparagraph 5 as subparagraph 4, and in subparagraph 4 as renumbered, deleting the word 5 and substituting therefore the word 3. And the third amendment thereto, renumbering subparagraph 6 as subparagraph 5. Final amendment to that clause, Mr. President, Mr. Chairman, is to delete subsection 2.
I put the
President, Chair, just want a clarification from the Minister. The effective date is the date of conviction, so that somebody who is convicted for 3 years, when they get out after 3 years, they can get, yeah. I just want to clarify. Conviction is the date, and I want that just for the record. It's the date of conviction that determines the length of.
Just one comment on that too. The wholesale importation into this of offences under the Dangerous Drugs Act, I think, is a little too broad, because they have offences under that act which are really not relevant at all to the question of whether or not you can be licensed under this act. Senator Knight may want to make the point, but I agree with the point that he
Yes, Chairman. I think it is far too wide. It is still an offense to be caught smoking ganja in public. And I'm asking, if someone is caught smoking ganja in public, that prevents them from getting a license? That's irrational. And so I would ask that they have to be far more specific. Okay, fine. So how do we proceed then?
We can. I'll just wait to receive a note on that, and we can come back.
I mean, one way would be to exclude, for example, any offence under the Dangerous Drugs Act which is punishable or which is subject to a ticket. Because
a ticketable
offence. I don't think that's the right language, because they don't use the word ticket, but that the effect. That would be one way of taking all of those cases out of it. Yeah.
But may I just say generally in relation to the offences, I've been thinking about it. And the bill, in a sense, is an unfriendly bill to those involved in the cocoa, etc., growing. It's unfriendly. For breaches of some procedures, breaches of regulations, the penalties are disproportionate. And this is not really intended to prevent persons from doing certain things. It's intended to encourage persons to conform, so that when you're looking then at the penalties, that must inform the policy regarding the penalties. In this bill, it doesn't. And so I find it a little bit difficult, Chairman. And I'm sure that you would. And were you able to put forward your thoughts, you would support strongly the view that I'm now articulating. Mind you, a nod would show the government side that you are in agreement. Thank you for the nod. I think we really need to look at it. We'll look at it again.
Do you have a comment on the dangerous drugs thing?
Mr. Chairman.
Yes, I'm hearing you from your incorrect seat, Senator Morris.
May I speak from a seat other than my designated seat, Mr. President? Okay. I just wanted to ask a question in light of the extensive amendments that have been proposed to the bill. What is the level of consultation that went into this bill with the relevant stakeholders? Because I find it very strange in light of the number of amendments that have been proposed.
I don't know if you want to address that at the end of the issue, rather than since you're trying to get through clause 18, you could deal with that at another juncture.
Sorry, Chairman.
Mr. Chairman.
No, that's procedurally that my good friend Senator Knight did not ask for permission to speak from a seat that was not his own.
Thank you, Senator Reid. But having spoken, the words cannot be withdrawn.
Mr. Chairman.
Tonight you receive retroactive permission to sit in a different seat.
Thank you, Chairman. Thank you. Thank you.
I don't want to get bogged down here. We have some amendments, but you can go ahead, Senator.
Thank you, Mr. Chair. I'm just seeking some clarification in terms of clause 18 that speaks to a period of 5 years or 3 years prior to the application, and I wondered whether this includes offences that were committed presently and would impact the coming into effect. And I ask you that because under the Agriculture Produced Act, I am not aware that that would have been a reason not to have a license. And it seems to me that if someone committed that offense 2 years ago and the act comes into effect at the end of this year into next year, then they would have been impacted by the provision, which seems to me a little unfair. And so I am seeking clarification whether that period of time starts to run as at the coming into effect date.
So far as I understand, when the Act comes into effect, then the 3-year period will be relevant in respect of the date of conviction. it will run from the date of conviction in respect of any matter which exists at the time that the act comes into effect. So that's how it is intended to operate, Senator Binns. In respect of the offenses, Senator Knight, and I'll wait for further guidance because this issue did arise. At the start of the sitting, when I was closing the debate, I mentioned the fact that we have made some adjustments, and those adjustments include the reduction of the period of time, the changing of some penalties to imprisonment only in default of the fine, etc. And because of and we've also separated growing from the regulatory impact of much of the other provisions, so that we think that the balance that's now achieved in respect of ensuring that this agri-industry which is being promoted will be one which will attract international trade partners without concern. We'll be able to ensure that issues in relation to development of other agricultural industry, that there's a new vision of how agriculture in Jamaica is being perceived at a level of integrity, I think, which was an issue raised on your side as well, while also ensuring that young persons and older persons who may have taken a wrong turn, etc., but wish to enter, that there is an appropriate balance at this time. Should it be that it is found at some point down the road, adjustments need to be made, then perhaps those can be considered. But we think an appropriate balance has been achieved, and I would definitely not describe this bill as unfriendly.
I represented an area where we have cocoa farmers in the Glen Gulf, above rocks area in particular. And these are some over 60 people who are really involved in it. And I just imagined a discussion with them, them saying to me, my MP, this is going to affect us. We're not going to be able to satisfy some of these, and if we don't, this is going to be such that we're going to end up in prison and that sort of thing. And so, whilst I haven't spoken with them recently, I have had a word with someone involved, and whilst the person did not use the word unfriendly, the position he put forward accorded with mine, that is unfriendly. But since you had broadened the discussion, for example, the fine, the custodial fine, and the monetary fine. My problem with it, as I had stated in the debate, remains. And I understand that some changes will be made, but there are some for which this status quo exists. Now, let me tell you the difficulty. Last time we dealt with this, I had a word with the chairman, and he said to me, but KD, at 2:30 every day, there is a fine and also the power for the custodial sentence. And as I pointed out to the chairman, the wording of the statute is different. In the dangerous drugs statute, it is specifically stated that it's consecutive. No, I would find it very difficult if it's made consecutive. I really would. But if it is not, then the provision is meaningless. So I really have to bring that to your attention. Although if I didn't, then the position that I stated in the debate would obtain. That is, that it will be concurrent. So again, it gives me a little feeling here of disquiet in that the policy relating to penalty had not been thought through from what I call A to Z, had not been. And even at this last moment, I am asking that we do not enact any provision which provides for both. It makes it here now, it's not unfriendly anymore. There's a antagonism setting in. It's wrong.
Yeah, and that point really relates to clause 14, which we've already gone through. But on clause 18, I just want to make a comment on the issue that we've been discussing. There's a sort of double whammy of retroactivity that could be involved here, because first of all, you have persons who may have been convicted prior to April 2015 of possession of a small quantity of ganja or smoking, who would be prohibited for 3 years from the date of that conviction or could be prohibited from getting a license, whereas prior to this bill being passed, that prohibition may not have existed because it wasn't a regulated activity. So in a sense, their conduct at the time that they were convicted is now being made subject to a further penalization which did not exist at the time that they were convicted. So there's that aspect of it. And there's the fact that the conduct itself is conduct which is no longer criminal. So, and yet they're being exposed to the potential exclusion from this industry on the grounds of past conduct which produced a conviction for something which is no longer criminal. So from both angles, I have an issue with it, and I would really ask the minister and the technical team to consider a subsection 2, because I think we're deleting the existing one, that would simply clarify that the reference to an offense under the Dangerous Drugs Act in subsection 1 does not include an offense to which they either identify the specific thing in the Dangerous Drugs Act or an offense which is subject to a ticketable, the correct language for an ticketable offense.
Leader, that point that you had made already, and that's what they're waiting for to hear from the technical people.
Oh, I thought that you had said that you weren't minded to make an adjustment to that.
It's something that had been discussed already, and I am minded to consider it. The position is that from a policy position, the concern is about the perception of the industry. And there's this concern because of its growth and development. And the truth is, when you're moving from an unregulated sector to a state of regulation, and or a very loose or light regulation to a firmer, more structured state of regulation. There is always some level of adjustment that persons need to make in terms of their conduct, the matters they take into consideration, etc. That is the nature of regulation. But in respect of matters which are no longer criminal, and in terms of matters which we feel that we have sufficiently defended on the international stage, I actually do feel that those should be excluded from being an offense here. So I'm happy to revisit the issue, and I have asked that it be considered. I won't stray from that into the other issues, but I do feel that that would be an appropriate treatment. So we are awaiting
Should we move on to clause 19 then?
Yes.
Just 1 second, sir. Whilst they're considering, for example, maybe the offenses under the Dangerous Drugs Act that you're really thinking of would be offenses like dealing in, exporting, you know.
Where I am with it is that, yes, there are different thresholds. I think that they rather than seeking to identify those which we wish to include, that we will identify those which we know we have already defended under decriminalization actions. So those which, as Senator Golding said, would now take a ticket, or
Can't just be that, because again.
No, but that
see,
sir, is where we are. That's the approach that I think we're going to take, because already the policy.
For example, Leader, somebody, a young person is caught, what's the term? No, not weed, no. Coke, what they call it. Snorting, whatever. That young person is caught with that.
Mm-hmm.
Not dealing in, not exporting, or anything. That person now, for 3 years, cannot be involved in this activity. So how do you get? How are you facilitating any rehabilitation and re-entry into the normal scheme of things? We must be clear that, look, persons who deal in drugs, who export drugs, we do not want them in this activity. Because for 3 years at least, because their behavior is inimical to it. But for persons who have transgressed the law in ways which are not necessarily inimical to that, why should they be prohibited? You know, that's why I'm saying we have to make this thing such that whilst we want conformity, there is room for those who have committed an error in behavior which was criminal in nature. And you don't keep them out, because if you do, then where they're going to turn. This may be a situation where, for example, one is going to inherit a farm from a relative, but he can't be licensed. So that farm now either becomes non-productive, or because in my situation, you know, there aren't very many of us who could have inherited anything because we have a small family. That exists.
Me too.
You know? No, I still have a small family. So in other words, leader, let's look at it in a humane way, a realistic way, and a way to preserve the essence of what we want. What we are doing now is not that.
Thank you, Senator.
So, Leader, would you like to come back to 19? I'm sorry, would you like to come back to 18?
Thank you.
Okay, so we're going to return to clause 18. So I put clause 19.
Mr. President, I'm also wondering, just so that we can proceed perhaps more expeditiously, where there are no adjustments to the amendments as listed, can we take them as stated, as set out in the list of amendments rather than reading through?
Once you have the agreement with the leader. So
I would, excellent. I'd propose that approach to clause 19, which is fairly uncontroversial.
Yes, there are amendments.
They're identified at the base of page 7.
Okay, so I put the amendments to clause 19. Those in favor? Against, I put clause 19 as amended. In favor? Okay, so there are no amendments, I think, to clause 20. So I put clause 20.
Aye.
In favor? Against? Ayes have it. I put clause 21. Those in favor? Aye. Against? Ayes have it. I put clause 22. In favor?
Aye.
Ayes have it. I put clause 23. There are amendments to clause 23.
There are amendments to clause 23, Mr. Chairman, and they are located at the end of page 7, proceeding on to page 8. Mm-hmm.
Mr. Chair, I'm just querying in 19(1)D, in the amendment sheet, there's a reference to subparagraph 1 and subparagraph 2, but in the bill itself, there are no subparagraphs in D. And in fact, the words that are being deleted are not in the bill, so we can't delete them. In the
I still believe that I need to get an answer to the question that I had asked.
I hear you.
Mr. Chairman, it appears that that was an editing error from an earlier version. But to make absolutely sure, I would ask that we perhaps not take that amendment and revisit 19. Or we let it sit and we'll recommit it to make the amendment after they have reviewed.
3.
Yes, we'll continue and we'll go back to 19 afterwards, and so that we can be absolutely clear, because something clearly happened in between versions. And I want to make sure what the error was.
So I put clause 24 then. Eh? 23 is the one you just recommitted, you know. 23 is the one.
No, I had made a comment about the fact that the amendment sheet had amendments to 19 that were flawed. We didn't recommit it. I was just bringing it to your attention, and yeah.
3.
As set out.
I put the amendments to 23. In favor? Against? So I put 23 as amended. In favor? Against? 24 I put.
Yes, Mr. Chairman, there are amendments to 24 located from pages 8 to 9 at the very top. If there are no comments, I would ask that the amendment to 24 be put.
Okay, so I put the amendments to 24.
Aye.
This is an instance where the modification of the approach to the penalty has been accepted.
Yes.
Yeah. This is really only in clause 14, I think, where it has been retained as being imprisonment or a
14
fine or
and
both.
29, predial larceny and the offenses that deal with the commercial benefit.
Right.
Yeah.
Yeah. All right.
Okay. So I put the amendments to 24.
Aye.
I put 24 as amended. The ayes have it.
Mr. President, there are no amendments from clauses 25 to 27 if you're minded to put those en bloc.
If there are no comments, I would put 25 to 27.
Could I just ask the leader? I don't have my actual bill before me. Remember, I raised a point about the prosecutor. That's it. Thanks.
So I put clauses 25 to 27 in favor. Against? I put clause 28.
There's an amendment to clause 28, Mr. President. And it's set out at the top of page 9. If there are no comments, Mr. Chairman, I would ask that you put the amendment.
So I put the amendments to clause 28. I put clause 28 as amended. Ayes have it. I put clause 29.
Yes, Mr. President, there are amendments to this clause, and this is a clause that deals with predial larceny in the context of regulated agricultural commodities. The amendments are set out on pages 9 to 10 of the list of amendments. And if there are no comments on that clause, I would ask that it be put.
I put the amendments to clause number 29. In favor? I put clause.
So this is one where in both the parish court and the Supreme Court, on conviction, the person convicted is liable to, in the case of the parish court, a fine not exceeding $3 million or to imprisonment for a term not exceeding 3 years, or to both the fine and imprisonment. And in the Supreme Court, to a fine which is an unlimited amount, or to imprisonment for a term not exceeding 10 years, or to both the fine and imprisonment.
I put the amendment to clause 29.
I really wish to propose that, and I hear the point made about this is pre-Larson, but in the Supreme Court, to both fine and send somebody to prison for 10 years, when judges are giving people 6 months and so for scamming, I think is excessive, and I'd like to recommend that for the Supreme Court, it not be fined and confinement, but
Senator
fine.
Brown, you just clarified that comment about judges sending the people to prison for 6 months. That's just a throwaway comment, or you want to elaborate on that?
I'm concentrating, Mr. President, on the issue of 10 years possibility for somebody being caught with pre-larceny, plus a fine which could be unlimited. And I think to have both a fine and 10 years is excessive. And I suggest, I'm recommending an amendment that for the Supreme Court, where the judges there can decide on the extent of the punishment, that it not be both fine and confinement at that level.
Thank you, Senator, for your suggestion. The truth is that a judge will have the opportunity to decide whether it is either or, but we are more likely to increase the penalties elsewhere than to reduce these here. We're quite clear that predial larceny is not to be tolerated. It will be addressed in other legislation where it exists and should properly be addressed in respect of other sectors and in respect of other fines or penalties which are not having the sufficient message sent about the seriousness of the crime and the seriousness that the government views the crimes with. We are not minded to reduce the penalty as stipulated here.
Sorry, I'm not asking for a reduce in penalty per se. We share the view that predial larceny must be attacked and punished severely. But where we're talking about a 10-year and an unlimited fine, I'm cool with either. But so I'm not opposed to being firm against predial larceny. What I'm saying that we must avoid excessive, and to give at that level the judges the authority to go fine up to 10 years and an unlimited amount of money could be excessive, and we shouldn't be pushing that, because as you have said, the judges will go between fine, confinement, but we should be giving them both. And I really think so.
Thank you, Senator. But the policy position is that we will give the judge the option to take either action. And Mr. Chairman, if I could ask that you put the clause, the amendment.
Sir, put the amendment.
Before you do so, just one point on this. In my presentation on the bill, I had made the point that this is creating a disequilibrium between the penalties relating to predial larceny for certain crops and for others. Yeah, we will address it elsewhere, but I don't know when that will be, because the relatively lenient treatment of predial larceny in the courts has been the bane of farmers for a long time, and I would have thought we should have used this opportunity to harmonize the provision so that by amending, rather than a piecemeal approach, we should have taken this opportunity to amend the other legislation so that the same sentencing and forfeiture regime would apply to both. I think it's a major failure of this legislation that we have not done that. I don't know how long it will take the ministry to get round to amending other pieces of legislation dealing with that.
I appreciate the perspective, but I think it would be a highly flawed approach to try to deal with regulating other sectors under a bill which specifically is establishing a regime in respect of regulated agricultural commodities.
Not talking about regulating anything else, just the penalties for predial larceny.
Offences in relation to predial larceny will be dealt with under the appropriate legislation. You cannot expand beyond the scope of what is relevant to this legislation. That's like trying to put in the climate change and food security that was otherwise suggested. They're not appropriate for this legislation. But we will not reduce the penalties that we are providing for here. We will increase penalties in the appropriate legislation. Mr. Chairman, if you could put the clause.
So I put the amendments to clause 29.
I just want to, I am not suggesting that we attempt to regulate other crops in this legislation. I'm simply saying that if you're creating a new penalty regime for predial larceny, for the offense of predial larceny in this, which is you're limiting it to the crops that this legislation addresses, you could easily at the same time have amended the legislation elsewhere to harmonize it, and that opportunity has not been taken.
We do not agree with the approach as suggested. We believe it's flawed, and Mr. Chairman, if you could put the clause.
So I put the amendments to clause 29. Those in favor? I put the clause 29 as amended. In favor? Ayes have it. I put clause 30.
In relation to... Go ahead. No, because there's an amendment. So you deal with the... Oh, she just... let me tell you. In a way, it is akin to the point you just made, which is that for obstructing, assaulting, hindering, resisting, if a citizen behaves in any of the described manner to a police officer, the penalty is really a totally different, and why I feel that this should accord with that under the Constabulary Force Act as against that act conforming with this is that it was recently amended to increase the penalty there, but I don't think it reached this level. And, whilst we can depend upon the good sense of a parish judge, and I have confidence in the parish judges in relation to how they apply penalties, I have confidence. The fact is that when the legislature sends this policy position to them, then they are inclined to act in accordance with the wishes of Parliament. And a realistic approach must be taken. For example, you hinder a person, an officer. He comes to your gate, to your farm, or wherever. You say, no, not letting you in now, so. No, you don't have your appropriate identification. I think you're coming to harass. You're not coming in. Charged, He's charged. He may not have had his ID at all. In truth and in fact, goes to court, and the judge believes him. It's a part of the system. But no, a fine $3 million, not exceeding $3 million. It's unfriendly. You are for yes, you're destroying them. These little farmers, I hear you talking about getting investors to come in from abroad and all that. But we have to think about that little farmer. that little farmer who breaches the law, and you are going to expose him or her to a kind of penalty that can wipe them out? It's disproportionate. It's not right. It's not right. We're too heavy-handed. We're too anxious to send people to prison. Senator, you don't want that. You don't want that. That's right. So don't open the avenue for it. If you don't want it, don't provide that it can be done. So it's not a matter now of you wouldn't imagine that a judge would do that. You have to imagine that a judge would do that because the statute says you can do it. So the judge would not be acting ultra vires. So yes. But you know, I will tell you, whilst I said that I have confidence in the parish judges, the discretion to sentence, and I'm going to use an age-old kind of analogy, varies greatly with the leg of the chancellor, the leg of the person who is going to sentence. You might sentence this person to $1 million, another 500,000, another 3 million. So what you have to look at is the upper end. The upper end, because if the upper end is high, then the probability exists for these people to be treated harshly. Yet you are legislating and you say, well, the judge has a discretion, so the judge won't impose 3 million. If in your mind and in your policy you are saying that 3 million is excessive, reflect it in the language, not in a hope.
Thank you, Senator, for your impassioned presentation on the matter. I think that we all understand your concern. We're heartened by your faith in the judicial system and the ability of parish judges to assess the difference between an offense by a small farmer who thought he was being harassed and a big company who decides that they're not taking any talk from an officer of a regulatory authority that's coming to inspect. And that it is that context, that flexibility, which is provided for here, where it simply states not exceeding. So the fine can be levied up to 3 million, so that the varying circumstances which may be presented. What I will say, though, Senator, so that we can proceed with this bill, and we still have another bill to take, is that we could raise...
Before you say anything further.
Just to say, this matter...
Before you say anything further, don't let the pressure of time prevent you from dealing with a policy issue properly, so that there's another bill to be taken. Is of no moment to this. You are trying to put into place something which is going to be regarded as permanent. It's not going to be for tomorrow. Senator Reid, as you would say in school, I'm addressing the leader. So the response should come from her. And so please, I don't want us to take an approach to this matter that will time be upon us today. And if you are to look at the policy closely and properly, and to look at how sentencing regimes are developed, you will see that this is out of whack. But go ahead. And you know what is going to happen? When you put a $3 million fine, and the magistrate fines the person $50,000, you know what is going to happen? You're going to hear public uproar. The judge fined the person $50,000 and it could have been $3 million, and we have no confidence in the justice system. And why don't they have confidence in the justice system? Because the legislators have taken so little time to put in an effective and properly thought through policy that in the end the judges become the scapegoats, when the persons who should be blamed are those who initiated the legislation. And what is happening is going to flip another way too. We have no confidence in these legislators because they know not what they do.
That having been said, I put the amendment to clause 30.
Aye.
Against? The ayes have it. Clause 31.
Mr. President, the amendment to clause 31 appears on page 10.
I put the amendments. I put the amendments to clause 31.
Aye.
Against? Ayes have it. Clause 32. I'm sorry. Yes, okay, so I put clause 31 as amended. I put clause 31. Ayes have it. I put clause 32. There are amendments.
Yes, Mr. President, the amendments appear on page 10 of the list of amendments.
So I put the amendments to clause 32.
Aye.
I put
A that appears on the list is just
It's an editorial.
Is an error.
It's an
All right.
I put clause 32. I put the amendments to clause 32. I put clause 32 as amended. Clause 33. There are no amendments on the list. So I put clause 33. Ayes have it. I put clause 34. There are amendments.
Let's put the amendments.
Mr. President, clause 34, the amendments to clause 34 appear at the base of page 10 onto page 11. If there are no comments, I would ask that we put the amendments.
I put the amendments to clause 34 in favor. Against? Ayes have it. I put clause 34 as amended. Ayes have it. I put clause 35. They are amendments.
Yeah, I have a comment on these amendments. It's just one comment. In 35.3, the scheme of it appears to be that the appeals are to be from decisions of the authority in relation to licensing. So it's an appeal from licensing decisions. But the way in which it's drafted, I think that it's a little ambiguous. It says a person who is aggrieved by a decision of the authority to refuse to grant, renew, suspend, or revoke a license, or any other person acting in the exercise of any function delegated under Section 5 may appeal. I think that the words relating to the person acting under in the exercise of a function delegated under Section 5 really belong a little higher in the provision, because it is a decision, it's a person aggrieved by a decision either of the authority or of a person who's acting under a delegated authority, being a decision to refuse to grant, renew, suspend, or revoke a license. It's that aggrieved person who may appeal. I don't think the intention is to make the decisions against, from which you can appeal wider in the case of appeals from persons who are acting on the delegated authority vis-a-vis the appeals from the decisions of the authority itself. I think the scheme is to only allow appeals from licensing decisions, whether it be granting, renewing, suspending, or revoking. The way it's worded currently, I don't think it works very well. So I would just ask that the Minister just ask the technical people to have a look at the first 4 lines of 3 and see if they can just improve that to make it clearer.
Difficulty with fine-tuning that point.
Thank you.
And we could therefore just suspend the debate on clause 35 and move to clause 36. But before we do that, Mr. President, if we could just recommit 32. A while ago, I just said that there was an error in respect of 32A, but there is not. There is a 32B which is not amended. So 32A is correct.
Okay.
So there's no editorial in there. It wasn't moved as an amendment, Mr. Chairman. I just wanted to clarify for the record. No change. Yes, and we're on to 36.
Okay, so I take clause 36.
There are amendments to clause 36, Mr. Chairman. They're located on page 13 of the list of amendments.
So I put the amendments.
Yes.
I put the amendments to clause 36. In favor?
Aye.
I put clause 36 as amended. In favor?
Aye.
Ayes have it. I put clause 37.
1 second, sir. On clause 37. Do we still have this in relation to offences under the regulations? This concept of imprisonment or a fine or both in subsection 3, and that seems to me to be worthy of reconsideration, given that we're not even talking about offences against primary legislation, but rather offences against regulations which don't even currently exist. So I would suggest that in the subsection 3, we adopt of 37, we adopt the normal approach, which is to say that subject to a fine not exceeding $3 million or in default of payment to imprisonment for a term not exceeding, well actually it's they've adjusted it to $2 million or in default of payment to a term of imprisonment not exceeding 12 months. So the amendment adjusted downwards the cap on the fines for offences under regulations from 3 to 2 million, which is agreed, and from 2 years to 12 months, which is also agreed. And I think if we could just adopt the basic formulation for less serious offences, then we would be ad idem.
And they not delete the R code, such fine and
They moved on. They're going to come back.
Marcus,
yeah.
I would delete our board.
Yeah, man. Which one are you talking about? You're okay with that from a policy perspective, the consistency with the approach that you would outline. Yeah. So they'll tweak that today. Oh yes. Right. While you're at it, while they're considering that point, on the same 37. we are adding 2 new paragraphs, inserting 2 new paragraphs in the list of things for which regulations can be made. There is no reference to certificates of registration here. And I was wondering whether it might not be a useful thing to include, although it talks about in 15.3 about prescribed form and manner, there may be other aspects of the regime around certificates of registration for which you'd want to provide regulations. And I would suggest that you might want to just use this opportunity to include a reference to certificates of registration here as one of the things that regulations may be made about. Yes, yes.
They are not significant. Can you wait, or you want to move on to 38? Okay, I'll wait.
Mr. Chairman, yes, if we could, I think there are 2 issues, that we're looking at?
That's right. One is in subsection 1, which is to include a reference to certificates of registration in the list where of things that you can make regulations
And
about.
others amend the penalties.
And others just to use
To
the
default of fine.
Yeah.
In default of payment of fine, given that they're administrative. Yes. So I've gotten the thumbs up on both of those. So we'll insert in in the new paragraph C, after the words, the establishment of procedures for and the specifying of terms and conditions for the grant of licenses and certificates of registration. Right, and in respect of 2, just ensure that we have the right formulation. We can come back to that, Mr. Chairman, on second thought. Let's just suspend the debate on 36. 37, there are no amendments to 38.
There are no amendments to 38. I put clause 38 of the bill. In favor? Ayes have it. 39.
Mr. President, the amendments in respect of 39 appear at the top of page 14 of the list, and I suspect there should be no concerns with this. If you could put the amendment.
So I put the amendment to clause 39. I put the clause 39 as amended. In favor? I put clause 40.
Mr. President, the amendments to clause 40 are also appear on page 14, addressing the exclusions from the assets to be vested. If you could put the amendment.
Just on that one, it is in 1B, right? Afterwards, yeah, that's fine. Thank
So
you.
I put the amendment to clause 40. In favor? Against? I put clause 40 as amended. In favor? Against? I put clause 41.
Thank you, Mr. Chairman. The amendments to clause 41 appear also on page 14. If the amendment could be put.
I put the amendments to clause 41. I put clause 41 as amended. In favor? Against? The ayes. Minister, before you go to the schedules, I would prefer if you go back to, I think that you have clause 2 was the first one where there were some amendments. It's 2 and 18, I think.
Mr. President, in respect of clause 2, here it is proposed to address the definition of commercial significance that is being inserted in clause 2. And so the amendment is to insert next, after the definition of coffee product, the following definition: quote unquote, commercial significance in relation to a regulated agricultural commodity, A, in section 2, 15.3 and 16.2 has the meaning specified in part B of the 5th schedule, and B, in section 16.1b, has the meaning specified in part A of the 5th schedule. And the consequential amendment to this, Mr. Chairman, is that subsections 4 and 5 of section 16 will also be amended by deleting them.
Yeah, I think that I take care of the difficulty that Senator Golden had.
Mm-hmm. On that issue. So again, that's clause 2.
Okay.
Just to clarify some, Mr. Chairman. Part B of the 5th schedule, if I could, because is this limited to a particular location? So I am growing 30 pimento trees in Trelawney, and over in St. Anna I'm growing another 40. That's 70. Is it location specific? Is it farmer specific?
It's specific to the
Because
individual.
if I have it in St. Anne in a company's name and another company's name, 2 different companies' name, same directors, would I be, I was trying to say, where does that leave that farmer or that group of farmers?
Come on now. You know,
We're making law to govern the life of people out there, and I'm trying to put a specific situation and to see how this law would address that. So, in other words, human nature, when we see these things, so that if I grow 50 pimento trees, then I have to be registered and so forth. But I could grow 40 somewhere and 30 somewhere and not have to register. So I'm trying to find out whether or not your understanding of the law combines the locations or so I could register under different company names and escape
conceivably
it.
you could. And at the point that you're actually seeking to do business other than grow is the point at which the authority would presumably come to awareness that you are, and there are questions as to whether that would actually be a sensible way to approach if it is that you're seeking to do business other than the small subsistence which is carved out in the Act for Small Farmers. If you are seeking to keep yourself small by incorporating and setting up a formal structure where you have new asset business tax and new minimum business tax and all those things to pay, while keeping yourself small, and you find that feasible, then that might be permitted by the Act. But it may not actually.
Are those the amendments to 2?
Yes, Mr. Chairman.
I put the amendments to clause 2. In favor? Against? Ayes have it. I think clause...
President, clause 4, just to confirm that in clause 4, 1, in subclause 1, well, sorry, I think we had confirmed the amendment to paragraph A, but in respect of F, we're confirming, yes, that
F.
the language will now read subject to subsection 2, comma, grant licenses and certificates of registration. So this will work together with the other amendment which we just spoke to. So if you
Excellent. So I'll put the amendments to clause number 4. Against? Those in favor? Against? Ayes have it. I put clause 4 as amended. In favor? Ayes have it.
And just checking, Mr. President, that you, Mr. Chairman, that you had
We hadn't
caught
dealt with-
the amendment to 2. to 4 subsection 2. That was under 1.
Yes.
All right, just making sure. That was the inclusion of import permit.
Yes.
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 So I'm just making sure that it was
Yes.
caught in the record.
Did I think that we were to revisit clause 18? You said, I have 18, you know.
In dealing with our amendment to clause 2 and a consequential amendment to clause 16, 4 and 5 was mentioned. Is that adequately addressing the fact that we've dealt with 16, or do we have to deal with it? Yeah.
You are absolutely correct, Senator Golding. Clause 16 it is. If we could go to clause 16, Mr. Chairman.
Yes, clause 16.
Yes, we will be deleting subclauses 4 and 5. So on page 6 of the amendment sheet, clauses 4 and 5 to be deleted.
So I put the amendments to clause 16.
Yes.
In favor?
Aye.
I put 16 as amended. In favor?
Aye. So now clause 19, Mr. Chairman, clause 19, the amendment should read, in paragraph D, delete the word against and substitute therefore the word under. And the amendment should end there.
Right. So there's only one amendment to 19.
Yes, so I put the amendment to clause 19. I put the clause as amended. I put the clause as amended. Ayes have it. I think that we were supposed to
There's
return
an
to
issue
18.
which I think was being considered in relation to clause 18 and the treatment that Minister had agreed with, that for the Dangerous Drug Act, they only deal with the non-ticketable stuff and not the ticketable stuff.
What I'm going to suggest in that regard, similar to what my thinking is in respect of the point made by Senator Knight, is that those issues be considered by the minister responsible when this bill returns to the other place where it must be considered, where these amendments must be considered. It's his policy at the heart of it, and while there has been some room to make adjustments, I would prefer that it be addressed by him, and I undertake certainly to raise the issue with him and to share my perspective.
Thank you. And so if he's minded to accept your perspective, which I hope he will be, then it would come back here afterwards for those amendments to be ratified. I think it would have to. Yeah. Yeah. I think if we amended it, he could decide whether to accept them or not. And it would save one extra leg of the journey, but it's up to you.
All right, so I put the amendments to clause 18. In favor? Against? I put clause 18 as amended. In favor? Ayes have it. To revisit 35.
If we could proceed to the schedule.
Just once here on 35, just a clarification, Minister. Under 8, on page 12, the appeal on the amendment sheet. The appeal tribunal shall hear each matter brought before the appeal tribunal and give its decision in writing regarding such matter within 90 calendar days of the filing of the appeal. Now, normally it would have been within a time period of determination after hearing the appeal and not within the period of filing the appeal. Is there a reason why there's a difference?
For persons not to
I was
be-
more concerned about the volume in a situation where there may have been numerous appeals to pressure the tribunal in this case. But
I think the aim is to try and make sure that there's not too much room created for dragging out procedures.
Can I?
Yeah.
Can I? Let me tell you what
Absent, extraordinary circumstances. Some exculpation.
let me tell you what causes me to think a bit about this. If the decision is not handed down within 90 days, what happens?
Does it nullify the...
And I tell you why I find it to be important. Because of the word suspend. That is one of the decisions that can be made, to suspend the license. And if within 90 days this decision is not handed down, the suspension order remains in place, so that now the what you call them, the farmer is in limbo. He can't do anything. So it exposes him to possible severe loss. How can we treat with that? And as Senator Gill pointed out, the 90 days from the filing, there is no, as I understand it, time limit in relation to, after the appeal tribunal is to within 7 days request the statements in writing. Now, the setting of the date, there's no time limit there that within 3 days of the receipt of that or X days of the receipt of that, a date shall be set. So that seems to be a lacuna. Then, so it may become unreasonable when, if a date isn't set, Senator Gill, for the hearing until 10 days, 15 days after the receipt of the documents, which is computed in the 90-day period, it may become unreasonable for the appeals tribunal to actually hand down their decision in the unexpired time, right?
Yes, I think it's
And you could have a real difficulty. Not so, you'd have a difficulty with any one of them, revocation, non-renewal, etc. But the one that bothers me most is the suspension. You follow me? And so I don't know how we can tighten it, but I think it needs some tightening. There has to be a situation, if the decision is not handed down in 90 days, and again I'm concentrating on suspension, then the suspension shall cease. Now, is it going to cease for another time period, or until the matter is determined? You know, I think we need to look a little bit more at the appeal procedure.
Another case, Chair, in another case, the tribunal in this instance could seek for an extension. Could seek for an extension. But there's no provision.
There's no provision
here.
for that, though. Yeah.
Within 90 days, so...
Could I also, I mean, if you look at the scheme...
Sorry, Senator, if it is that the organization, the tribunal must organize its business in a way that allows for a ruling to be handed down within 90 days because it is mandatory that they so do.
No, but you're putting an onus on the tribunal that
doesn't control all the moving parts.
Exactly.
Yeah.
It's not in control. It does not, for example, where it says here, where is it
The
again?
authority doesn't give the reasons for the decision.
Within the time. You know, they must give the decision, the reasons within the time. If they don't, then that affects
Perhaps
it.
they may have to dismiss the appeal.
But may I make a suggestion?
Does it say?
At the expiration of 90 days, they must either dismiss the appeal.
But they can't. It's not realistic.
Or allow the appeal. Meaning
If they
have three powers.
if they haven't heard the matter because the facts are not before them, they can't determine the appeal without the information being before them and hearing. I think if you look at the scheme of it, paragraph, Mr. Chairman, paragraph 7 speaks about the appeal tribunal causing all parties to be informed of the date of the hearing of the appeal, etc. So there's a process of information gathering and filing. A date is then set, and the tribunal informs the parties of that date. 8 now deals with time frames, and I think that 8 should say that if the matter is not heard within 90 days of the date for which it's set down, then any suspension order that is subsisting shall lapse until the matter is finally determined. Yes. And that's it.
And for myself, as I said, I would confine it to suspension order. I'm not going to the non-renewal or revocation. It is the suspension that creates the uncertainty that a farmer cannot live with.
Non-renewal is also an issue because you can't farm.
My reason for raising the concern, is really to protect the tribunal in case the tribunal is not able to hand down a decision within the 90 days. So there has to be a period allowable for the tribunal to be able, as soon as possible, as soon as practicable after, something to govern that in order to protect the tribunal.
I agree. I think that if you put a mandatory obligation on the tribunal to render a decision within 90 days of the appeal being filed, when the necessary steps for them to even determine the matter don't lie within their control, some of them will be in the authorities' control, you're creating a potentially untenable situation. It's the wrong structure.
Or as soon as possible thereafter, cover it.
Yeah. I think there needs to be some language as soon as practicable thereafter.
We're going to move to the schedules while the technocrats have a look at that.
Chair, we're on 35. We're looking at...
We're looking at 35, Senator Brown.
Yeah, just a concern, and maybe... Yeah, just another concern. I'm not sure, Minister, that the farmer who has to appeal, I see the tribunal is entitled to receive all the documents, but the documents on which the decision to turn down the farmer's request might have been made. There's no provision here which says the farmer is entitled to that so that he may pursue those documents before the tribunal as part of his case.
Says that the notice shall set out clearly the grounds and shall be accompanied by copies of any correspondence, document, inspector's report, or any other statement relevant to the appeal.
That's the point. That's the point you're making. There needs to be a...
6, if you were going to deal with it, 6 should require that the reasons for its decision furnished should be shared with the appellant.
And relied on in arriving at that decision.
You can just... Grandson, help her. You could just put in a full disclosure clause, provision, because policy-wise, she's not against that. You understand me? So just to make the thing easy, so that we can move ahead, because we have another bill to consider.
It's not a perennial, Charles. The time is now 1:20. I do report progress and seek the leave of the Senate to sit again. Those in favor? Against? Ayes have it. I do report progress. Huh? You.
Mr. President, the time. Yes. Mr. President, the time being 1:20, may I ask that standing orders be suspended to allow the Senate to complete the business of the day, to sit beyond 1:30 and complete the business of the day.
The question is that the standing orders be suspended to allow the Senate to sit beyond 1:30 to complete the business of the day. Those in favor? Against? The ayes have it. The Senate will now resolve itself into a committee of the whole Senate to continue in committee stage in consideration of the bill clause by clause. We are awaiting some assistance in relation to 37.
Provisions. And one possibility would just be to add a paragraph that says the penal tribunal may make such orders or give such directions in relation to disclosure as may be fair in the circumstances. Let's empower them to deal with that. You know. Yeah.
While that is being done, can we go to the schedules? I do put the first schedule of the bill. Those in favor? Against? The ayes have it. I put the second schedule of the bill. Those in favor? Against? The ayes have it. I put the third schedule of the bill.
On that, so just to note that in the item 2 of the third schedule, in the amendment, well, there's an amendment to that, so I'll let the Minister take you through the amendment. But it's just to point out in 2, in item 2 of the amendments to the third schedule, where it talks about delete paragraph 2, the 2 that's being deleted shouldn't have brackets around it. It's not a bracketed provision. Yeah.
Okay, we see that.
Yeah, but I just want to make sure they delete the right thing. Yeah.
All right. So I put the amendments to the third schedule. In favor? Against? Ayes have it. I put the fourth schedule, to which there are no amendments. Yes. Those in favor? Ayes have it. I put the fifth schedule. There are amendments, I think.
Amendments to the fifth schedule are located at the base of page 15, continuing to page 16.
And I was suggesting that language be added to the fifth schedule to indicate that these quantities or amounts or more are deemed to be significant. Yeah.
Minimum quantity of regulated.
I think whether you call it minimum, I'm not sure, but I think we need to have some language. Yeah.
I had agreed. So
Yes. Yes.
The suggestion is minimum quantity of regulated agricultural. Just adding
Minimum
the word
quantity
minimum.
that is commercially significant.
That is of commercial significance.
Yeah.
To insert the word minimum before quantity
Yes.
in the heading.
So
It
I
is
put
minimum,
the,
yeah.
It is.
So I put the amendments to the, it's the fourth, is it?
To fifth.
So I
Fifth
put the
schedule.
amendments to the fifth schedule. Those in favor?
Aye.
Against? I put the fifth schedule as amended. Those in favor? Ayes have it. Against? I put the sixth schedule. There are amendments.
Mr. Chairman, the sixth schedule is the amendments to the sixth schedule which address the health and food safety standards are set out on pages 16 to 17. If you could put the amendments.
So I put the amendments to the sixth schedule. Those in favor? Against? I put the sixth schedule as amended. Those in favor? Against? Ayes have it. I put the seventh schedule. There are amendments.
Yeah, just two comments on the seventh schedule, sir. The first concerns paragraph 2C, disqualification from appointment to tribunal. A person shall not be qualified for appointment as a member of tribunal who, and C speaks, has a direct or indirect proprietary interest in more than 5% of, and it says any class of shares of an enterprise that deals in a regulated agricultural commodity. I don't think the words any class of shares of are helpful because it may be directly owned by this person through any entity that has a share capital. So I think the words in C are sufficiently broad that it would cover a situation whether the ownership is through a directly held interest or an interest through some form of entity that has shares. If it was just said, has a direct or indirect proprietary interest in more than 5% of an enterprise that deals in a regulated agricultural commodity, because it says direct or indirect. And I think the use of the words any class of shares limits it in a way that is inappropriate.
I don't think it's unusual language for statutes, but I don't have an issue with taking that out.
No, it's not. The concept of class of shares is not unusual. I'm saying it narrows this.
I don't have a problem. I'm happy to accept that amendment.
All right.
That on page 18 of the list of amendments, Mr. Chairman, in item 2, disqualification from appointment for tribunal, that subparagraph C be amended by deleting the words
any class of shares.
Any class of shares of. Leaving the clause to read, has a direct or indirect proprietary interest in more than 5% of an enterprise that deals in a regulated agricultural commodity.
Yeah.
Okay, thank you, Minister.
And the other point, there are two. The other point relates to costs, which is paragraph 17 of the schedule. And it says that the appeal tribunal may order a party to a proceeding before it pays the costs of another party and the tribunal's costs of the proceeding. It doesn't have to be on the face of it the losing party that is made subject to an award of costs. And I just thought that was a little odd, because the idea would be presumably if the farmer has appealed successfully then the costs ought to be borne in the normal way, follow the event, and the costs ought to be borne by the losing party, which would be the authority, I assume. And it also contemplates the tribunal's costs being borne, which is a lot of money, and I thought this would have been, I would have thought that the cost of the appeal tribunal would be part of the budget. Is it anticipated that it's going to be borne by the
I have gotten a lot of costs, but
I mean, when you before that,
And Chairman, I share the view of my colleague on the matter of cost. I think that the approach to the tribunal, Minister,
I mean, if you look at clause 13, it says expenses, accommodations, and other facilities of the appeal tribunal shall be included in the budget.
I think your point has been taken, and she's seeking some instruction.
I was just bringing a relevant provision to the attention of persons who may be interested, because there is a provision that says that the costs of the authority are to be. Well, I'm not really gilding it. I'm just setting out a relevant fact that it's borne out of the budget.
In respect of the schedule, so it's being suggested that we remove the reference to costs in their entirety, being a tribunal.
Excellent
where it is not
idea.
necessary.
Okay.
So 17, 1, 2, 3, and 4 would be 17 would be deleted in its entirety.
Was that a suggestion of Senator Brown?
no, it wasn't. Chairman.
Excellent. So I put
Chairman. Yeah.
So can I put the amendment?
No, Chairman, I have a concern. I have a concern in clause 1 of the Constitution of the Appeal Tribunal. It gives the minister the authority to appoint 3 panelists. I would have think that, page 17, I would have think that what would have is that the minister selecting from a group from recommended by farmers, and then the minister select one from that. But what is said at B is that the other members shall be selected from among persons who appear to the minister to be qualified as having had the experience, etc. And what I think should happen is he should approach the farmers to name, give him a list, and from which he pulls. No, I don't think you understand what I'm saying. The minister now appoints the three. That's what this constitution says. But he doesn't consult with anybody. And what I'm recommending, as in the model at the Industrial Dispute Tribunal, where the minister select from a group recommended by, he appoints the chairman, he selects from a group of individuals recommended by the employers, and a group from the chairman. May I be allowed?
You can talk, you can go ahead, but I thought the minister says that,
I am.
So what is it? Just suggest the amendment, Senator Brown, please.
Yeah, but the constant interjection of policy, which sound to me like, we are telling her to tell me it's policy.
I'm telling her
no,
to
I'm
tell
just
you
telling
what.
you, President. So he's just echoing what you said. Sorry, my apology then. Let me just get, what I'm saying is that rather than the minister appointing all three panelists, that he will, on his own, that he consult and select from a group recommended by farmers. But if it's your policy to exclude the farmers from or not to have consultation, then cool. But one would think if we're developing legislation with a sense of fairness and participation of the people, we would not limit it to the minister, whoever he or she may be, to be the sole person who chooses the panelists for the appeal tribunal. I am seeking to get the involvement of the stakeholders in making recommendations. You may not be familiar with the IDT model, but it's a model that has worked since 1970 and has earned the respect. And what we don't want is for ministers to, well, let me not put it this way. I don't want a situation where the choice looks so fair, so unfair in the composition of the panelists that people feel that they've lost before the case even starts.
Thank you, Senator. Mr. Chairman, what I had forgotten to ask you to do is, after deleting clause 17, paragraph 17 in the 7th schedule, was to renumber paragraphs 18 and 19 as 17 and 18.
So I put the amendments to clause 17. Those in favor? Against? I put clause 17,
Schedule, 7th schedule.
7th schedule, I'm sorry. I put the amendments to the 7th schedule. Those in favor?
Aye.
Against? I put the 7th schedule as amended. Those in favor?
Aye. Mr. Chairman, I have an amendment to clause 35 that addresses the concern about the language in the first 4 lines. And the amendment reads as follows, or the amended clause reads as follows. A person who is aggrieved by a decision of the authority or by any person to whom a function of that authority has been delegated under section 5, and then it continues as set out in the original bill. That is, to refuse to grant, to renew, suspend, or revoke a license, may appeal to the appeal tribunal by way of a notice of appeal within 21 days of the date that the aggrieved person is advised of the decision, or within such longer period as the appeal tribunal may, in special circumstances, allow, and in accordance with the 7th schedule.
Thank you. So I put the amendments now to clause 35. Those in favor?
Aye.
How are we dealing with the 90-day issue? Can we just add a such longer period as the authority may reasonably require? Just add those words, a such longer period as the authority may reasonably require. So at least it's not willy-nilly.
Come now, Mr.
Tribunal, appeal tribunal. Such longer period as the appeal tribunal may reasonably require.
You have that, sorry.
Unusual, Minister. I know you don't want to encourage slackness in the system, but it's most unusual to tie. It's most unusual to tie a time frame for determining an appeal to the date that it was filed, when there are all these other persons who have things that they have to do for which no time frames are provided. Huh?
Hold on.
90 days from filing.
Is it filing from filing?
Yes, 90 days from filing.
Yeah, it can't work.
No, it cannot.
Speaking, it's not a good idea in these sorts of scenarios to just have an immutable time frame which can never be adjusted. You don't know what there may be force majeure, somebody may fall sick, a hurricane could hit, a panelist dies. Yeah.
The proposal, Senator Golden, is what?
The proposal was, in that paragraph,
90 days or what?
Or such longer period as the appeal tribunal may reasonably require.
As soon as possible thereafter. As soon as possible thereafter.
Mr. Chairman.
Wait
And
with
colleagues.
bated breath.
Yes. This is not in respect of the seventh schedule, but it's good news in respect of clause 18. Because, yes, dealing with the conviction under the Dangerous Drugs Act. So we've made contact with Minister Samuda, and the perspective has been shared. There has been some back and forth, but we think we have an appropriate solution now. So
Recommit.
I would ask, Mr. Chairman, that we recommit clause 18.
The question is that clause 18 be recommitted. In favor? Aye. Against? Go ahead, Minister.
Yes, and the proposed amendment is in respect of subparagraph 3, and again, we're dealing with the exclusions or exemptions from entitlement. So has been convicted of an offense involving fraud, dishonesty, or moral turpitude, or an offense under the Dangerous Drugs Act, other than an offense which attracts a sentence of imprisonment of not more than 5 years during the period of, I think we have to switch it around. We'll have to switch it around. Here it is. Has been convicted of an offense involving fraud, dishonesty, or moral turpitude, or an offense, open parentheses, other than offense which attracts a sentence of imprisonment of not more than 5 years, close parentheses, under the Dangerous Drugs Act, comma, during the period of 3 years immediately preceding the application for a license. So it's taking out any of the less serious offenses under the Act, which presumably and will extend beyond the ticketable
So they
offenses.
look through the Dangerous Drugs Act to see whether 5 years is an appropriate threshold?
I presume this is where the time went. Most of the offenses are 15, 20, 25, and then beyond that.
But some of them in an
it's actually
RM
much
court.
less.
Some of them in an RM court under that act. Most of them are in the RM court.
It hasn't spoken to the
I know, but I'm
the
just
court
wondering
of jurisdiction.
5 years seems high. That was, yeah.
So I take the amendment to clause 18.
Aye.
Eh?
I make sure that they have thought as to
Yes, they're
what,
fine.
yeah.
So I take the amendment to clause 18.
But is it only to one provision? Because the same provision is in D. In what was the D4? I think it's become, we deleted D4 and it became D4. Yeah. So the same amendment should be made to both.
It's in
It's in C3, right? And then C3 was modeling what was D5. And because we're adjusting the model, we should adjust the mold, which is D5.
no, we had changed.
We deleted D4, and we renumbered 5 as 4.
Yes.
Yeah. And we changed 5 to 3 years. But with the same amendment you're now making needs to be made to D, what is now will be D4, what was D5.
Hold on, I think I have a numbering issue here. 1 second.
Look in the bill itself, page 13. Roman 5 is now being renumbered as Roman 4 because we're deleting, yeah. And I'm saying in that substantive provision that was D5 and is now D4, the same amendment that you've just done in relation to C3 should be made to the wording there as well. It's the same issue. Any of its directors have been convicted of any offense involving fraud, dishonesty, or moral turpitude, or an offense, open brackets, not being one which attracts a penalty of more than 5 years, close brackets, under the Dangerous Drugs Act. It's the same point. Yes, this is, yes. So the same, substantially the same amendment there.
Okay. Ready, Minister? So I can take the amendments to clauses 18, the amendments to clause 18. Those in favor? Against? 18 as amended. Those in favor? Against? Ayes. You have anything else? Are we through? Yes.
Chairman, if we can recommit clause 35.
So
And then I think this is it.
the question is that clause 35 be recommitted. Those in
Yes.
favor? Against? Yes. Go ahead, Minister.
And the suggestion is that in subsection 8, so we're in 35.8, addressing the matter of time, after the word calendar days, the words or such longer period as the appeal tribunal may require, comma, not exceeding 14 calendar days. You're permitting for extension of period of time where something unforeseen has happened, but we are not going to leave an open-ended extension of time so that people are handing down decisions or having hearings, you know, next year, day after, next 3 years, when a farmer's license has been suspended or revoked and they're unable to do business. We want the time to be constrained. The concern raised was that the time was too fixed and that was unlikely to be workable. So the suggestion that is made is an extension by 14 days. Mr. Chairman, could you put the amendment, please?
So I put the amendment to clause 35. Those in favor? Against? I put the clause 35 as amended. Those in favor? Ayes have it. Okay. What's that, Senator Golden?
Clause 37 so needs to be recommitted just to sort out the language that in subsection 3 dealing with in default of payment. It was just a simple issue, but the wording had not been settled. You were sorted. Yeah, I mean, I think it was just to get the formulation from them for a term of imprisonment or a fine or in default of payment. A term. I'm sorry, I wasn't being impolite. I don't think there was any lack of politeness.
Okay, so we're back with the language for 37, the amendment to subsection 3, Mr. Chairman. And for simplicity, if we can just delete the subsection and instead replace it with the words, notwithstanding section 29 of the Interpretation Act, regulations made under this section may prescribe greater penalties than those specified in that act, and the maximum penalty that may be so prescribed shall be a fine not exceeding $2 million, and in default of payment, a term not exceeding 12 months. If you could put the amendment.
Thank you very much. I put the amendment to clause 35.
37.
I'm sorry, 37. In favor?
12 months. What did I say?
Against? So I put clause 37 as amended. Those in favor? Aye. Against? The ayes have it. Excellent. I put the title and enacting clause. I put the title and enacting clause.
Sorry, Mr. Chairman, I just want to make sure that it said in default of payment, imprisonment for a term not exceeding 12 months. Okay.
So I put the title and enacting clause. Those in favor? Against? The ayes have it. The question is that the question is that I do report the bill as having passed the committee stage with 73 amendments. Yes, sir.
I had asked a question earlier about the extent of consultation that went into this bill. And the bill has been passed with 73 amendments, and I am certain that if there was proper consultation with the relevant stakeholders, that we would have completed our work.
Senator Morris, I'm going to allow you to say what you want to do, but there is a question before the Senate, because I did say that I do report the bill as having passed with 73 amendments, those in favor, those against, and I didn't get a vote on it. So may I have a vote on that? Those in favor?
So you're going to take the vote?
No, man, you can.
But you take the vote before. Anyway, Mr. President, but the fact of the matter is that I want to know the extent of the consultation that has gone into this bill, and because I have seen a trend developing. A bill was circulated yesterday, another issue, and that bill has been withdrawn from the lower house because of lack of consultation. So is there a trend that is developing? What is the situation in terms of consultation?
Is there a trend developing, Minister? That's the question.
No, there is not.
Okay, thank you. I do report the bill as having passed committee stage with 73 amendments.
73 amendments. And there's not a trend in lack of consultation.
Ask the third reading. You asking for the third reading? What? Yeah.
Mr. President, I ask for third reading of the bill.
Third time. Those in favor? Against? The ayes have it.
A bill entitled An Act to Establish a Body to be known as the Jamaica Agricultural Commodities Regulatory Authority for the Development, Regulation, Promotion and Standardization of the Agricultural Commodities Industry and for connected matters read a third time and passed.
Mr. President, it is now intended to take the proceeds, the Act to amend the Proceeds of Crime Bill. Mr. President, the bill before us is a short one. It essentially seeks to delete one word from an act and replace it with two. It replaces the words land valuation in section 9.3 of the Proceeds of Crime Act and replaces them with the word lands, changing that section's reference from the Commissioner of Land Valuation to that of the Commissioner of Lands. A simple matter, but one of great importance, and one which is consistent with the government's commitment to, one, taking the profit out of crime, and two, increasing the efficiency of government processes. Mr. President, among other imperatives, we must have systems in which the state works efficiently so that our strained resources can be channeled most effectively. We know that since the Proceeds of Crime Act was passed in 2007, it has been used to forfeit millions of dollars in assets, and these assets have been redeployed in one way or another to support the government's fight against crime. The government's ability to treat with forfeiture and monetization of real property, however, Mr. President, and the ability to do so in an efficient manner, that has been stymied by the two words mentioned at the start of this presentation. Mr. President, as you're aware, the Proceeds of Crime Act was enacted to provide for the investigation, identification, and recovery of the proceeds of crime and connected matters. The Act provides for an asset recovery agency, which is the Financial Investigations Division, and the Financial Investigations Division was established by the Financial Investigations Act, through which it is empowered to investigate financial crimes and connected matters by managing, safeguarding, maintaining, and controlling any property seized or restrained under its governing legislation, as well as those restrained or forfeited under any other enactment in connection with proceedings related to financial crimes. Mr. President, it's important to note that the FID has extensive powers under the Proceeds of Crime Act, POCA, and the FID under POCA has the power to secure the detention, custody, or preservation of any property vested in it by a recovery order pursuant to civil proceedings. In the case of property other than money, the FID is empowered to realize the value of the property for the benefit of the FID. Where property which is the subject of a recovery order includes real property, the order will vest that real property in the Crown. Now, Section 9 of POCA addresses the status of real property once the court makes a forfeiture order after conviction. And the property will vest absolutely in the Crown by virtue of the order. This applies also when a foreign confiscation order in relation to real property is registered in Jamaica. Section 9(3)(a) and (b) provide that where property against which a forfeiture order is made, the property vests in the Crown in equity, but not at law until the applicable registration instruments have been complied with, and the Crown is entitled to be registered as the owner of the property. Section 9(3)(c), however, gives the Commissioner of Land Valuation the power on behalf of the Crown to do or authorize the doing of anything necessary to obtain the registration of the Crown as owner. This, however, is an error of the law, as the appropriate person or entity to exercise these powers should be the Commissioner of Lands, pursuant to Section 4.2 of the Crown Property Vesting Act. So the Commissioner of Lands, Mr. President, is appointed under Section 3 of the Crown Property Vesting Act, and that act sets out the powers of the Commissioner and the limitation of these powers. But for our purposes today, the most important or relevant point to note is that the fundamental power of the Commissioner, its purpose in fact, is to acquire, hold, and dispose of land and other property of whatever kind. This should be compared to the powers of the Commissioner of Land Valuation, a commission established under Section 16(a) of the Revenue Administration Act, for the purposes of exercising powers set out under the Land Valuation Act. And as the name suggests, the powers and limitations set out in that act are generally established for the purposes of land valuation, as opposed to dealing with the transfer, conveyance, or other treatment of land required for ownership to change. So, Mr. President, this is not a simple law revision error, it's a fundamental error. And it has been posing legislative difficulty when utilizing the section to have property registered in the name of the Crown. And this has been hampering the efforts of the FID. As we speak, in fact, there are several applications currently before the court for forfeiture of assets post-conviction, which are languishing there. Mr. President, the FID, having held forfeited properties for an extended period of time, the longest being up to 5 years, has found it necessary to pursue other circuitous routes in order to transfer these properties to the Crown. And on a number of occasions, they have had to go back to court to obtain further orders so as to give the Registrar of the Civil Division of the Supreme Court the power to sign on behalf of respondents and convicted persons who are either unwilling or unable to sign the instrument of transfer. This is highly inefficient, Mr. President, and counterproductive for reasons among the following. The applications to obtain orders so as to give the Registrar of Civil Division of the Supreme Court the power to sign on behalf has to be done on a case-by-case basis. So each time it's required, the FID has to return to court, and all of the delays that entails. The process is accordingly, Mr. President, very time-consuming and costly. And fundamentally, the intention of Parliament is not being fulfilled as the Commissioner of Lands is unable to carry out her required mandate with respect to the matters which fall under POCA. It is in this context, Mr. President, that the bill is before us today for consideration and approval, hopefully. So just a very quick clause-by-clause examination. Clause 1 cites the name and short title of the Act as the Proceeds of Crime Amendment Act 2016 and provides that the said Act shall be read and construed as one with the Proceeds of Crime Act and all amendments thereto. Clause 2 seeks to amend Section 9(3)(c) of the Proceeds of Crime Act by deleting the words land valuation and substituting, therefore, the word lands. In closing, Mr. President, the amendment to Section 9(3)(c) of the Proceeds of Crime Act, if approved, will allow for the naming of the correct person or entity, that is, the Commissioner of Lands, so that the powers vested in the Commissioner under the Crown Property Vesting Act can be exercised. This would empower the Commissioner to effect the registration of the Crown as owner of the various pieces of real estate that are the subject of forfeiture orders or recovery orders, so that these assets may be disposed of and the proceeds made available to the Crown or the FID, as the case may be. Mr. President, it is in this context that I put this bill for consideration of my colleagues, and I hope for its support. Thank you.
Mr. President, the bill is an extremely short bill. Essentially, as has been said, all it is doing is to change the reference to Commissioner of Land Valuation in that section of POCA to read Commissioner of Lands. It is in the context of the brevity and simplicity of the amendment that we had no objection to the bill being tabled and debated on the same day. The standing orders don't generally allow that, require that bills be tabled and a period of notice be given so that people can read them and think about them when it comes to the debating of them. However, from time to time, it's necessary to abridge that. The urgency of this particular bill has been mentioned by the Minister, and because of its simplicity, brevity, and so on, we had no objection to it. It's a fairly elementary piece of legislation, and we support it. Thank you.
Mr. President, Senator Charles.
Yes. Mr. President, as said, it is a relatively short bill and certainly a simple error that has been amended, but simple error that will have great effect. Mr. President, I rise to support the bill and to indicate that by rectifying the designation and the name and the reference in the bill, what we'll be doing, Mr. President, is strengthening the administration of justice in this country, particularly so as there are a total of 29 forfeiture orders, Mr. President, that have been received over the past 5 years, in excess of $500 million worth in value. And only 6 of those have been able to be passed because of the circuitous process. 19 remain. And we can anticipate that with this amendment, we look forward to those being expedited. Mr. President, I will also say in support that the FID previously would have had to, after receiving the forfeiture order, go back to court to obtain further orders. And that in itself, Mr. President, is something which I'm certain they look forward to not having to do ever again. Mr. President, I stand in support. I also do know that Senator Golding and the opposition stand in support, and I do believe that this simple bill should move forward. I thank you.
Mr. President.
Senator.
Thank you very much, sir. Today we dealt with a bill that required 73 amendments in this Senate. A bill that came from the other place with some amendment, no doubt. There's a saying that you, Mr. President, would recognize from St. Elizabeth, that ace makes waste. While we support the bill, while we have agreed to facilitate the suspension of the standing order to take
Senator, would you clarify which bill are we talking about? Because the one
Sir?
that's being discussed is, I see you're going back to poker, right?
No,
Or you're addressing,
I've always been on poker.
or you're not addressing the bill that's on the floor. I'm asking.
I'm addressing this bill that is before us, Mr. President, an act to amend the Proceeds of Crime Act.
Okay.
And I've said, because I'm laying the foundation for a point about ace making waste. And while we must be careful when we take these bills on short notice, I spoke earlier as part of that thesis of the 73 amendments we did today. I want also to mention, because there's a fundamental principle for me, I raised it last week about the short notice that we got in respect to Part B of the schedule of the Restorative Justice Act. And as a senator, I demand that we must all be allowed to examine what the minister speaks, that this is a bill that is not just correcting an error. It's a fundamental piece of legislation that is being brought. That's what she said. I take that seriously. Last week, I made the issue about the restorative justice schedule being rushed through and being provided to us with short notice and insufficient time to deal with it. Last week, we also dealt with another bill and a resolution for which inaction had taken place. Senator Charles brought that bill, a bill passed, but an order not made. That order was made last week. In other words, what I'm sensing is that the way we are doing business here is either by rushing, and as my friend said, limited consultation or no consultation, ace makes waste. That's the point I'm making, and that this hasty bill before us, which has not allowed me, because I'm hearing there's 29 cases. I would love to know how effective poker has been. I'd love time to look to see whether we're really taking the profit out of crime. Because it's either that crime is so profitable, while we have such an upsurge in crime, even our students being affected. So much so that tomorrow we will seek divine intervention and have a day of prayer for the protection of our students against criminals. Because it seems to be profitable to steal cell phone from students, even at the price of killing our youngsters. It seems to be profitable to shoot up a bus with students. So I'm not sure. I'd love to know whether poker is working and whether, therefore, we should be amending this piece of legislation. Truth is, if it works, it has my support. But I don't know, with the fear gripping the society. I said it last week and I say it again. As a parent, and there are many parents in this country who send their children to school, their precious child, the apple of their eyes, and worry every minute of the day whether or not that child will come back home alive. So when we look at this bill to amend the Proceeds of Crime Act, I don't know how many of the criminals who are preying on our students have land, and whether this bill will impact them. But it's clear to me that something has to be done about the crime in our society right now. And if this bill helps, so be it. It will have my support. But I'm not really sure, because the society is cowering with fear from all other crime that is taking place. And I make the point, Mr. President, because as we approach a situation of no quorum in this Parliament, in this Senate, as we approach a situation of no quorum in this Senate, I wish it to be known that we have to go beyond promising people. Have to go beyond promising people that they can leave the doors and windows open and wake up alive
Mr. President,
in the morning.
Mr. President, on a point of order, may I speak from a seat?
State the point, Senator.
I think this, I've listened to the Senator, but I really believe, based on the memorandum on objects and reasons of this particular bill, he's stretching it more than a bit. And I urge you, Mr. President, to caution the Senator. The memorandum on objects of the bill is clear, it's explicit. It's the point of order, Chair, is the relevance to which the Senator is stretching the debate.
Point stated, Senator, very clearly. And can you continue to discuss the business at hand?
Mr. President, I wish to bring to your attention that we do not have a quorum at this moment, and I ask you to indicate to me whether in the
We will break for point taken, Senator. We will break for 5 minutes to reconstitute quorum.
And implementing branding and marketing strategies emphasizing green elements of tourism, providing green investment incentives, promoting investment in and providing incentives for small, medium, and micro enterprises, and leveraging public-private partnerships. The scoping study recommends that government sends the appropriate signals through policies and regulations that incentivize green investments while disincentivizing brown investments. The aim is to guide private and public consumption away from practices that are harmful to both public health and the environment.
Also, what was important was the management of human and social capital. You can't grow an economy without well-educated, qualified, technically qualified, and otherwise qualified people. And one of the big problems in moving countries towards a green economy was a shortage of people who could do the job, whether it be adopting green technology or whatever it might be. There was a shortage of people, and not necessarily a program to train those people.
Now, construction industry, to go to a global view now, it really affects many of the Sustainable Development Goals, including Goal 6, water, Goal 7, energy, Goal 8, jobs and economic growth, 9, infrastructure, 11, sustainable cities, and 13, that we overall protect the planet.
Ultimately, the success of greening the economy will depend on the profitability of green investments and creating solutions by aligning the goals and interests of all stakeholders.
Thursdays at 9 p.m. for the people that truly matter. The fans. Watch PBC Jamaica for boxing heroes of yesteryear.
Ali covering up while Joe flails away, and Ali got it.
Thursday night at the fights, exclusively on PBC Jamaica, the people's station for good, wholesome family entertainment.
Welcome to an episode of Security Matters, the program that takes you behind the scenes of strategic departments of the Ministry of National Security to show the dedicated teams working hard to make Jamaica safer. Commander Antoinette Weems-Gorman speaks to some of the challenges faced in protecting our vast maritime space.
We are trained and equipped to deal with the threats that evolve in the maritime space. As an island state, we do have a very large maritime jurisdiction. We do have the responsibility to enforce maritime law enforcement. We do maritime safety roles, which include search and rescue. Each year we rescue between 250 to 300 fishers or persons in distress at sea.
The commander explains how the Jamaica Defense Force is working to stem the active gun for drugs trade between Jamaica and countries such as Haiti.
Jamaica lies in a very strategic location for good and bad reasons, being that we're in the middle of the consuming and the producing countries for certain narcotics.
So this is the Caribbean Military Maritime Training Center's Naval Bridge Simulator. It's the most advanced unit in the Caribbean at the moment. In here, we train officers from the entire Caribbean region. The simulator here, we actually have running our own ship model of the HMJS Surrey. So the ship construct, it looks on the outside just like the Surrey. It handles just like the Surrey in the seaway. So the training of the seamanship evolutions will be as per in the real world. We can train our candidates here not only in local ports, but all the international ports in the world.
The shipyard agreement that allows us to interact with or do joint operations with our international partners to conduct law enforcement. The JDF Coast Guard is strategically located around the island. So we have 5 outstations. We actually operate one from Pedro Keys, which is about 70 miles offshore. And we are not doing this alone. The Coast Guard is a part of the Jamaica Defence Force. And so we do have the support of the other elements of the force, which includes primarily the air wing, but in some instances, other parts of the force as well.
We now upgraded to 2 DA-40 and 2 DA-42, which we use to train pilots from several countries, such as Guatemala and Chile, just to name a few.
This is the CMTC Firearm Training Simulator. What we'll be doing now is doing a grouping practice. The candidates on the line will be firing at the targets to their front. This Megate Firearm Training Simulator is the most advanced within the region. It operates over Bluetooth, which allows much more flexibility within the training regime.
In the Department of Aircraft Technician Training, we offer courses in performance, orientation, electronics training, and this is a precursor to the avionics trade, airframe and engine training, avionics, aircraft maintenance management, and aircraft structural repair. This is the aircraft maintenance training hangar. It is a replica of the rail maintenance workshop. Inside here now we have the aircraft structural repair course, consisting of 6 locals and 4 international students, 2 from Belize Defence Force and 2 from the Trinidad and Tobago Defence Force. We disassemble, inspect and repair aircraft in this hangar.
I'm Las Capra Mendez from the Belize Defence Force. I'm doing a structural repair course here at Jamaica. The course lasts for 16 weeks and we are here with my colleagues doing the practical phase.
Here at the Caribbean Military Aviation School, we have the DA-42 flight training device. It's a level 5 simulator. We use it for flight training on our multi-engine course. We also use it for the instrument phase of our primary flying training. This gives us the ability to allow students being trained here at the school to fly to various airports all across the region.
The Jamaica Defence Force is working hard behind the scenes and on the front lines, employing state-of-the-art technology and world-class training to ensure that our borders are protected from the land, sea, and air.
Thank you, Senators. We now have quorum again, and I'm going to ask that given that we really are now speaking about changing 2 words into 1, not even 1 into 2, can we just try and close this part of debate so we can finish the business of the Senate with all due respect for the rights of everybody to speak. Thank you.
May I continue, Mr. President?
Senator Brown.
Thank you, sir. Now that we have a quorum, Mr. President, may it please you that I will say no more so that the bill may be passed. I've said enough, and I really want to warn the government that we must stop the bungling and get things properly in order in the Senate. May it please you, Mr. President.
Thank you for closing. Senator Brown.
There's nothing further at this time, Mr. President. Could we move to committee? Let's ask for second reading of the bill.
The question is that the bill be read a second time. Those in favor? Those against? The ayes have it.
A bill entitled An Act to Amend the Proceeds of Crime Act, read a second time.
The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. I put clause 1. I was moving a little bit fast there, Senator Brown, if you notice. So now I do put clause 1. Those in favor? Those against? The ayes have it. I put clause 2. Those in favor? Those against? The ayes have it. I put the title and enacting clause. Those in favor? Those against? The ayes have it. The question is that I do report the bill as having passed committee stage without amendment, sorry. Those in favor? Those against? The ayes have it. I do report the bill as having passed committee stage without amendment.
Mr. President, I ask that the bill be read a third time.
The question is that the bill be read a third time. Those in favor? Those against? The ayes have it.
A bill entitled An Act to Amend the Proceeds of Crime Act read a third time and passed.
Thank you, Mr. President. May I ask for recommittal of notices of motion given orally, Mr. President?
The question is that the item, notices of a motion given orally, be recommitted. Those in favor?
Aye.
Aye. Those against? The ayes have it.
Mr. President, I beg to give notice that at the next meeting of the Senate I will move, be it resolved that the Insurance Amendment of Schedules Regulations 2015 under the Insurance Act, which were laid on the table of the Senate on the 10th day of November 2016, be referred to the Regulations Committee of the Senate for consideration and report. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of standing orders to enable me to take this motion.
Those in favor? Those in favor? Those against? The ayes have it.
Mr. President, I now move for the suspension of standing orders for me to take the motion, notice of which I gave earlier.
Those in favor? Those against? The ayes have it.
Mr. President.
Senator Brown?
Yeah. I haven't seen the documents that have been referred to that have been tabled today. So I don't know where we're going to take it. Again, it's consistent with the point I've been making all along.
I see documents. We have moved along in the technological age to use soft copies.
Mr. President, I ask that the motion be approved. I understand that the link had been circulated, and this is a tabling of the motion, the submission of the documents to Regulation Committee. It's not proposed to address the matter substantively now or to look at the documents. It is to ensure that they are before the Regulations Committee.
Those in favor? Those against? The ayes have it.
Mr. President, it is not intended to do any further business today. I ask that the Senate be adjourned for a date to be fixed.
The question is that the Senate be adjourned for a date to be fixed. Those in favor? Those against? The ayes have it. The Senate is adjourned.
That is how he is respectfully known, for Nana means the very great chief. Everyone throughout Ghana knows his name, his power, and his influence, for his titles and positions are many. He is a member of the Council of State. He is president of the National House of Chiefs. And of course, he is king of the region known as Dorma Ahenkro. Excellency, was your father also king, or were you elected?
I belong to a particular family here in Dorma, that is the Atwansi family. And we are many in this family, potential chiefs. And it is the responsibility of my divisional chiefs, who are kingmakers, to select one from the family. So I was selected because I belong to this family. But the elders had a choice, and I was their choice.
Could you be dethroned or ousted by a group or individual?
I installed a chief for life. But if you do things against the will of your chiefs and the people have a customary right of what we say here, destooling, that is removing you from office. Apart from you could inform your chiefs that has in view of health reasons or age or whatever reason, you could abdicate. And of course, the natural one is for you to die when you are called to your ancestors.
Some 500 kilometers from Accra, the capital of Ghana, surrounded by a dense tropical jungle, sits Dorma, the heart of the Nana's kingdom. With 30,000 inhabitants, it is a city, not a village. And it is here that Nana Adyamank Badu rules. He is the master, though he is required, if not to share his power, at least to listen to and often comply with the wishes of a woman, the Queen Mother. For unlike most other ethnic communities, the ancestry of the Akans is traced through the mother. Each Akan's bloodline comes through his mother. Each Akan claims his mother's lineage. And for this reason, throughout history, Akan women have been treated with diffidence. And it is for this reason also that here in Dorma, the king is always accompanied by the one the people call the Queen Mother. Yet she is neither the king's mother nor his wife. Rather, she is the Queen Mother because it is from her clan, from her blood, that will come the future king. And it is she, the Queen Mother, who will enjoy the great privilege of selecting and submitting for approval to the elders the successor to the throne of Dorma. She is of royal ancestry. She is the great niece of the king's sister. She also lives in a palace, may marry, and in the event of the king's death, she will retain her title and functions of Queen Mother.
The Queen Mother is a member of my council. So she's one of the chiefs who constitute the traditional authority, members of which I consult before a decision is taken.
At the king's side, the young Queen Mother learns the business of being queen. How long has the Queen Mother been at your side?
Just over 4 years. A few days ago, we were celebrating her 4th anniversary.
9 a.m. That particular morning, on the road to the palace, a strange procession moved. slowly. The most important people in the province were coming, at the invitation of the king, to pay homage to their queen, the Queen Mother. Each of them duty-bound to keep this important appointment at the palace. (10:15 a.m., arrival at the king's palace. Each one carries his own stool, the ultimate symbol of the chief. To the Akans, the stool is an extension of one's self. With the years, it becomes imbued with the spirit of its owner. It is the foremost possession, for it is authority and power. 11 a.m. In the first courtyard of the palace, the guests are waiting. In the second courtyard, the royal procession is in place. The king's arrival is imminent. The Queen Mother, comfortably settled in a sedan chair, approaches the palace. a.m. The king joins his guests in the first courtyard. On each side of the procession, huge, brightly colored panels shield the Queen Mother from the curious eyes of spectators. (11:15 a.m. The Queen Mother enters the palace of the king. Nana welcomes her warmly. And one by one, the barefooted chiefs come forward to greet the Queen Mother, pay homage to her, and assure her of their loyalty and devotion. Befitting great chiefs, the royal faces remain inscrutable. And yet, to the considerable delight of the spectators, one after another, the youngest chiefs, supported by their close ones, improvise mythical dances, their arms outstretched in a sign of communion with their chief. (12:15 p.m. The king approaches the microphone. The kingdom of Dorma honors the Queen Mother. I ask for the help, the cooperation, and the support of all the chiefs. May they join with me in congratulating the Queen today celebrates the 4th anniversary of her nomination to power. May she enjoy many years as leader of the women of Dorma. I advise her to be an example so that all the women may join us in developing Dorma and Ghana. Near the king, the town criers call the gathering to order and ask for absolute silence as they invite the crowd to listen to their chief. Then they all return to their homes, the chiefs to their tiny kingdoms, the Queen Mother to her own palace. In his living room, Nana Agyemang Badu listens, as he does every evening, to the voice of America. And like every evening, he is joined in this by his wife. She shares no part of her husband's public life and has no particular power. With the help of her servants, she prepares the king's meals and spends the remainder of her time in a school near the palace. Everyone knows that she is not a teacher like the others, and yet her simplicity, her devotion, and her gentleness are such that her students occasionally forget that she is the wife of the king. They have children, but none of them will inherit from their father, as this is a matriarchal society. In Ghana, the Constitution guarantees and defines the functions of its chiefs. They hold real moral, social, and political power, power which is exercised within traditional boundaries. And so it is that, at Dorma, the king occasionally allows his chiefs to challenge him.
Our system is very democratic indeed. I needn't necessarily issue orders to them. What I do is to summon them to a meeting and discuss problems with them and discuss policies with them. So when they become decisions, I would have taken the decision with them at a meeting, and therefore they would have been part of the decision.
And yet, because of his great reputation and considerable experience with power, Nana Agyemang Badu is a man who can occasionally allow himself to command and make decisions on his own, something that occurs once a week when he settles litigations. He listens to the plaintiffs and the defendants and acts as a judge. But there is also a central power. The high officials of state, the representatives of Accra, who must apply the politics of the President of the Republic and his ministers. Can there be a conflict? Are there two parallel powers in Dorma?
We have our separate and clearly defined responsibilities. He is the representative of the central government and sees to it that government decisions and programs are carried out and implemented in the district.
Because of certain unhealthy dealings, they are not receiving our share of petroleum products here. And I'll be very grateful if the district chief executive and the council and the heads of departments will discuss this problem and try to find ways and means of resolving it. Thank you very much.
In discharging this responsibility, he needs my cooperation. He needs the cooperation of the chiefs and elders. And in this respect, he discusses the matter with me, and together we plan how best to implement the decision.
Here in Dorma, there is no apparent conflict between the two powers. The high officials respect Nana's talent. They never forget that he is president of the National House of Chiefs, that he has traveled, seen, and met with all the greats of this world when he represented Ghana at the United Nations in New York. And so, once in a while, the king remembers. He remembers his 30 years of struggle and his dreams, which he either abandoned or which ended in disappointment. He lacked so many things to be able to achieve his plans. But then, he will never forget his encounter with the Pope and the extraordinary impression this man made upon him when he greeted the pontiff in the National House of Chiefs. Together, they had talked extensively of the new relations the great powers should keep with the Third World.
We have a very optimistic view of the world. We hope that by the grace of God, the East-West conflict, the term, will become more stable, and that the world powers, both East and West, will have a humanistic view of the world and spend part of their acquired wealth in helping the third world countries to develop. When the whole world is developed, I think it will be a better world. I will have equality, we'll be able to sit down through United Nations and discuss the welfare of mankind as a whole. So we in Ghana, as an African country, we want East-West return. We want unity and cooperation in the world so that we will have peace and stability in our country to improve the human quality and living conditions. I think, first of all, a chief must have the necessary quality of being able to listen to his chiefs. And second, he must be courageous. When he sees the truth, he must have the courage to stick to the truth and to tell his people what is the truth. He must be kind. He must have the ability to forgive and forget.
Watch Something More on PBCJ TV every Sunday at 9:30 a.m. and a repeat on Sundays at 9 p.m. See Dynamic Ministries. Experience worship beyond the veil. The uncompromised Word of God from Bishop Dr. Harold V.
In
Blair.
the name of Jesus, every chain shall be broken. Every chain shall be taken.
That's Something More, Sundays at 9:30 a.m. on PBCJ TV. Don't miss this opportunity to be blessed.
As an inner city youth, I'm a duty to know my rights. Not because you see me on the corner, you are going to abuse me.
I have a life to live. I deserve to be heard and respected. But know my rights. Know your laws. Know your rights. Respect you.
Pitched, flat, arched, or gabled. It's the last uppermost line of defense against the elements. Vital cover for your valuable possessions in the face of nature's fury. Roofs are essential to a complete, properly constructed house. And in climates like ours, must be laid to withstand destructive tropical cyclones, not least among them, hurricanes.
The three main types of roofs that we have in common practice today are concrete, timber, and a combination of those two with other materials. Hurricanes differ in their velocity or speed of the winds that might affect our buildings. So you've got to make sure that the structural integrity of the members are sufficient to bear the pressure that a hurricane wind would place on a roof.
Concrete roofs generally prove more difficult to destroy in a hurricane, but if improperly laid, are just as vulnerable to grave damage.
There's a great misconception about the concrete roof being all that waterproof. But from time to time, depending on the mix and the maintenance of the roof, water could pond on the roof and soak through cracks that would appear because of shrinkages that take place. So you've got to be careful and make sure that you provide an impervious layer to the concrete.
So before one slabs, an engineer must be consulted. The correct procedures must be adhered to protect your roof and the valuables it protects.
This is a clay tile that is often used on certain types of residential construction. It's impervious, it will not contribute to fire, and properly secured with fastenings, it will withstand most hurricanes. It was not desirable to lay flat because the water would go into them. This is another example of the sheeting that is commonly used on residential buildings. It's extruded aluminium sheeting. You see where the V goes up? There's a wooden fillet that is placed there, and each of those are secured by a screw. That enables the roof to stay on even with high winds. These are examples of the shrinkage cracks that you can get in your concrete slab. This slab roof has been rendered since it's been constructed. Yet still, from time to time, you will still get these shrinkage cracks. And once they're there, water can percolate through.
Revelation. We found ourselves traveling through the accents of music.
I've got a great idea. Can't tell you now. So stick around and see for yourself.
Lucifer, time to rise and shine. Kissy-fur, I thought I told you to pick up your... Oh, Kissy-fur. Kissy-fur.
Oh, morning, Dad.
I do believe I asked you to clean up your room, son.
But, Dad...
And after school, I do believe you're going to set the table, take out the trash, put your toys away, and bring in some firewood.
Oh, but Dad, guys and I are going to build our new clubhouse today.
Sorry, little bear. Chores aren't always fun, but they're how we get things done.
Oh.
Aren't we forgetting something? Cheer up, Kissy-fur. You just took care of your first chore.
Boy, all I ever do around here is work.
Oh, that's more like it.
Gotta go to school, Dad. Bye.
Class dismissed, children. Have a nice little old day now, you hear? And don't y'all forget your homework tonight.
Yes, ma'am. Boy, between schoolwork and homework and all the other work, we'll never build a clubhouse.
Ducky, what do you think life would be like without grown-ups?
It wouldn't be good. It wouldn't be bad.
Well, then how would it be?
That's all you ever say.
Wait! Ducky's got a point there!
Yeah, him got lots of points.
Listen to this, guys. We can build our clubhouse in a secret spot where there are no grown-ups. We'll never have to work again.
I like it. I like it. Just so it's not, you know, dirty. I say it's a dumb idea.
Wanna bet? You guys meet me tonight at the mud flat, and I'll show you the perfect place.
We shouldn't be sneaking off without telling someone, you know.
What's the matter? Scared? So where's this perfect place you've been bragging about, sissy face?
Right there.
It is perfect.
Yeah, perfectly dumb if you ask me.
We didn't ask you.
But what about gators?
Don't worry, Stuff. They sleep at nighttime. Or is it daytime?
Hey, who turned out the dumb lights? Oh, I knew this wouldn't work.
What was that?
Ooh, dirty, slimy alligators. What?
Nothing. Nothing. It's just a nice dream. Go to sleep, little flower.
Nighty-night.
Night-night.
Shut your face, chump. You're disturbing my beauty sleep.
Let go. My dinner's getting cold. See there?
Told ya this wouldn't work. Told ya.
Don't worry, Toot. You're gonna saver. Uh-oh, now I'll really get
Oh, them juicy little varmint fiddles. Gone!
Oh, jam your jaw, will you? We're still gonna have them for dinner. I got a foolproof plan.
Is this great, guys, or what? Beautiful, you're the greatest.
Ha! This place is D-U-M. Dumb. See?
Let's get inside. Inside what? That's what.
Tell us, come on. Yeah, Jesse, I mean, what? Tell us, huh? I mean, come on, tell us.
A clubhouse. A clubhouse.
Right, a clubhouse.
But where is it?
How about right here?